Let me just say hello and really very, very warm welcome to everybody who is joining us today. My name is Bojana Bellamy. I'm the president of the Center for Information Policy Leadership, and together with Laura Schertel, I'm delighted really to be able to welcome and host everybody for this global data protection dialogue that we are hosting in Brazil, and because of Brazil as well. Well, we are not actually live in Brazil, but I wish we were. Those of you who have been working with us for some time, and especially on our project on Brazil LGPD formation and implementation, will remember that we actually held our first global dialogue live in Brasilia, in the beautiful auditorium of IDP, and with lots of foreign dignitaries and privacy experts and regulators. And now, 6 years later, we are back again, but in a virtual context. I very much hope that next year really will be live for us, and we will be able to again meet properly and exchange views and experiences. I want to extend my really warm welcome to the ANPD, the Data Protection Authority, and all of the directors there. In particular, Valdemar Gonçalves Ortuño Jr., who is our keynote speaker as well as Simon McDougall, our second keynote speaker. And thank you so much to all the other data protection authorities, experts, panelists, CIPL members and speakers who will be speaking today. And thanks to Brazilian friends and colleagues for joining us. Maybe I wanted to just reflect a little bit upon the 6 years that have passed since we have done this global dialogue. And I think that there are probably 3 or 4 things that have happened in these 4 years. Laura and I are a little bit older, but wiser and better for that, right? But apart from that, I think we have really entered what we call the 4th industrial revolution, where we have seen this massive digital change, disruption, and innovation take place. And these are some amazing stats. Last year, we are all in lockdown, right? 2020 was a strange year for all of us. But each minute of the day of 2020, Zoom hosted about 200,000 participants in meetings. WhatsApp users shared 1.5 million messages. Instagram users posted about 350,000 stories. YouTube user uploaded 500 hours of video. Twitter gained, 350 new users each minute of each day. And that shows you really the kind of acceleration and revolution that we are now living, and how data and data about people is actually critical for that industrial revolution. So maybe just the next slide. What I think we have experienced in this 4th industrial revolution is really how data has been critical for absolutely all players, right? It has become the driver of the economy and innovation. And I remember when Miriam Wimmer was still at the Ministry of Economy and doing some amazing communications and doing some amazing roundtables and workshops and also research, how we talked about Brazil wanting to be part of that digital economy and have its right place there. And that's true for absolutely every country, right? Every country and every company as well. It is driver of growth for all of us. Data, of course, has been a critical asset for businesses and government, and everybody is trying to make most of the data they have and be able to share more data. It has also delivered increased value for people, for consumer, like all of us, right? Because we are now able to access things like education or health, and of course, all amazing services that we use every day. Data for social impact and data for good have been big movements that have taken place in this past few years. And because of COVID, we have even more impetus and wish to use data for good and for social impact. We also want to use data to level our economies so that there is a more economic and equality around the world as well. And then, of course, global data flows absolutely are increasing economic growth. And we always keep looking at McKinsey data, which is showing how GDP of every country is growing because this country is able to participate in global data flows. And then finally, we have seen huge adoption of AI technologies, right? Companies and countries are now competing on ability to use AI to foster economic growth, to get insights, to be able to create new products, services, and effective government. And again, ability to use AI very much depends on our ability to have data, to train these algorithms, to make sure they're non-biased, and to be able to access pool of data that is beyond just one country, right? So this is kind of revolution, that kind of benefit and opportunity that data is bringing to us. At the same time, we are seeing, and we have seen in these past 6 years, some different, if you like, tensions as well. First of all, we have seen the rise of privacy and security regulation, and now we are talking about post-GDPR era, right? GDPR has been a beacon for many countries and has set somewhat the scene, but we are going beyond now, right? GDPR is already 3 years mature, so we want to kind of see what the next looks like. How do we implement these rules in post-GDPR era? The second important tension, or it's not a tension, but it's actually a trend, is that governments are also realizing the importance of data, and therefore there are kind of two trends. One trend is that governments are absolutely including data into their economic, industrial, and even foreign policy. So now we talk about free flows of data and trusted free flows of data as a matter of G20 meetings, and it was set up for the first time in Japan. G7 meetings that UK is going to be hosting this year already have got the whole ministerial side track on digital and data, right? And this trusted data flows, or free data flows with trust, is going to continue as a movement. But at the same time, we see some governments perhaps closing their borders, wanting to amass more data because they think this is better for them. And so that these data localization issues are rising, and therefore we've got OECD, for example, at the moment, trying to resolve some of these tensions around data localization, which is absolutely the right thing to do, because everybody in this global economy has to have access and ability to participate in this new data world, right? So these were some of the tensions, and what this means for us practitioners is that data privacy is not just a question of legal compliance, right? It isn't just about how we comply with the law, but it's actually how our companies are able to leverage and use data in a responsible and accountable way so that we can navigate in these new uncharted waters where data is a major asset, where countries and governments are asserting sovereignty, but also wanting to ensure free data flows, where this is part of economic policy and this is part of our business objective. And I think that is the last trend that I think we are going to talk about that today, that we are seeing this agenda about responsible use of data, accountability, corporate digital responsibility grow in its importance and become more of a board level issue than perhaps it was before. So that's really what has changed, I believe, in these 6 years. And COVID has actually just accelerated that change. It has made the case for data, it has made the case for accountability, it has made case for data sharing and use of AI, and for better distribution of data as well in our world. So I think with that, maybe let's move on very quickly to sort of our day today and day tomorrow. We have got some really stunning keynotes, panelists from all around the world, and I know we'll have a great chance to debate some of these topics. And today we are kicking off with day one. And perhaps before we go with our keynotes, if we can just I would like to spend 2 minutes very briefly, and I pass on to Laura, explaining, sort of why are we in Brazil and what we are trying to achieve here, particularly in respect of our Brazilian project. So those of you, if we can just move to the next slide, Isabella, please. If those of you who know us and have been working with CIPL know that we have been involved in Brazilian journey to data protection for many years, and it has been an absolute pleasure. And I have learned so much in that process. I was always incredibly impressed by the sophistication of the debates here, by the multi-stakeholder approach in Brazil, willingness to hear and learn, but also to contribute to the global debates, right? And that's why we have actually a year and a half ago launched this new project that is now looking. Now we have got LGPD, right? That's what's also happened in the 6 years since we've met. Finally, we've got a very modern law. We've got a very modern data protection authority. And we, together with Laura, CEDIS, and IDP, and Danilo Doneda, who couldn't be with us today, have launched this project to ensure we have got forward-thinking, future-proof implementation of the law, to ensure we do information sharing between various stakeholders, but also importantly with the new IMPD as well, and that we also create and learn from each other, exchange experiences and create best practices, all in order to create really effective LGPD that is properly implemented, and that also sets as is a beacon for other countries to follow, right? I always talk about that there are many countries that are looking to Brazil, how Brazil is going to be regulating and implementing LGPD. And we have published a number of papers so far, 2 papers particularly in the past year on the IMPD priorities and priorities for implementation in-house with companies, what are the top priorities for implementing LGPD? And we are continuing this project with 4 more papers planned for this year. We've done a number of webinars, workshops, and we will continue to do that in the years ahead. So I'm really delighted that we've partnered with Laura. I really hope we get more Brazilian companies, those who want to lead, who want to be responsible businesses, coming and joining us, sharing their best practices. And really, this is a chance for us to also bring to you, Brazil, some of the best minds from around the world and have that exchange of ideas, experiences, and thoughts. And so with that, Laura, I ask you please to introduce yourself and a little bit about our project, and then we can kick off the day for today.
Thank you very much, Boiana. Muito obrigada. É uma honra e uma alegria poder abrir esse seminário, esse segundo diálogo global de proteção de dados, ao seu lado, Boiana, com todo o time aqui do CIPL, com a Giovana, com a Isabela, do nosso time do IDP. E é um prazer muito grande dizer que esse já é o segundo diálogo global, mostrando uma parceria de longo prazo, ao longo já desses 6 anos, e num contexto em que a proteção de dados no Brasil e no mundo, né, como você muito bem colocou, se alterou bastante no Brasil ao longo desses últimos anos, e em especial no ano passado. Eu sempre digo que o ano de 2020 ele foi um ano muito determinante para a proteção de dados no país. Em primeiro lugar, porque a gente teve o início da vigência da Lei Geral de Proteção de Dados. Então, se antes nós discutíamos, em muitas situações, sempre o projeto de lei, como essa lei poderia ser formada, né, desde o ano passado nós temos a lei em vigor e precisamos, então, discutir a sua aplicação. Como se dará essa aplicação de uma forma adequada, de uma forma equilibrada, né, de uma forma a gerar confiança dos cidadãos no fluxo de dados na sociedade brasileira. Então, nós temos o início da vigência da lei, nós temos a criação da Autoridade Nacional de Proteção de Dados, que também foi um marco no fim do ano passado, e o terceiro marco em 2020 foi o reconhecimento pelo Supremo Tribunal Federal de um direito fundamental à proteção de dados. Eu diria que esses 3 marcos mostram como o contexto da proteção de dados no país se alterou, como isso cria grandes oportunidades para toda a sociedade brasileira e que a gente agora precisa discutir concretamente como se dará a aplicação desse marco. Eu queria trazer aqui alguns desafios próprios aqui, com uma visão olhando para o Brasil. Quais são alguns desafios que me parecem que a gente tem nesse momento? Em primeiro lugar, essa lei ela acaba trazendo uma regulamentação nova, porque ela regula o fluxo de informação. Então, diferente de outras leis, diferente da Lei de Defesa da Concorrência, do Código de Defesa do Consumidor e de tantas outras leis que já temos no país, essa lei regula o fluxo de informação. E identificar essa natureza própria do que está sendo regulado é o primeiro passo para que a gente possa compreender e criar um arcabouço institucional, uma arquitetura institucional apta a fazer essa regulação de forma adequada. Então, esse é o primeiro ponto. O objeto regulado, ele é muito diferente. Nós estamos regulando informação, não estamos regulando propriedade, não estamos regulando, eu diria sequer, relações obrigacionais, mas estamos regulando o fluxo da informação. O segundo elemento desafiador é que a natureza do dado pessoal e a natureza da informação é sempre fluir. E esse fluxo, ele se dá em âmbito global. E, nesse sentido, me parece que... Por isso que esse nosso projeto, Boiana, com o CIPL, desde 2015, essa parceria, ela sempre foi tão importante para o CEDIS e DP. Nós consideramos que é preciso enxergar a natureza global desse fenômeno. Não é possível enxergar apenas localmente, é impossível regular, porque se o dado ele tem essa natureza de fluir, se nós sempre olhamos esse fluxo global, a nossa regulação, o nosso arcabouço regulatório precisa, então, estar apto, precisa ser sensível a essa natureza. E, nesse sentido, então, eu queria dizer que acho que esses são os dois grandes desafios. O terceiro, eu queria também trazer aqui rapidamente, o arranjo institucional brasileiro. É claro que, como cada país tem um arranjo muito próprio, e nós temos um arranjo muito próprio, nós temos a Autoridade Nacional de Proteção de Dados e temos muitos outros órgãos que também lidam com a natureza, eu diria, difusa dos direitos, com a proteção de direitos fundamentais. E isso, é claro, também traz um desafio em termos de coordenação institucional. Com tudo isso, e em razão de tudo isso, nós acreditamos muito nesse projeto com o CIPL, que já então está agora nesse seu segundo ano, com todos esses elementos aqui que a Boiana citou, 3 eventos já desde 2015, 7 eventos planejados aqui em 2021, 2 papers já publicados, e temos ainda pelo menos 4 papers para serem publicados este ano. Então, é um projeto muito ambicioso. Nós acreditamos que, por meio de um diálogo sério, técnico e multissetorial, nós conseguimos encontrar aí o melhor caminho da interpretação da lei e de tornar a LGPD efetiva. Essa é a razão do projeto, e com isso, então, acredito que esse diálogo global será mais uma grande oportunidade para que a gente possa discutir os temas centrais, como regulação responsiva, como a Boiana aqui muito bem colocou, como coordenação interinstitucional e também aspectos específicos da Lei Geral de Proteção de Dados. Então, com isso, eu queria dar as boas-vindas a todas e a todos e dizer que é um grande prazer, mais uma vez, estar aqui com essa parceria, agradecendo tanto a Giovana Carlone, como também a Isabela Rosal, por todo o trabalho à frente desse projeto. E, com isso, eu queria chamar, então, dizer que é uma grande honra para nós poder convidar o nosso primeiro keynote, Dr. Valdemar Gonçalves Ortunho, presidente da Autoridade Nacional de Proteção de Dados do Brasil. Dr. Valdemar, é uma honra tê-lo conosco. Gostaríamos, então, de chamá-lo para fazer a primeira palestra. O senhor tem a palavra.
Obrigado, Laura. Inicialmente, eu gostaria de parabenizar a organização do evento. Eu acho que é muito importante nós discutirmos bastante este assunto que cada vez mais está mexendo com a vida de todos, não só os brasileiros, mas de todas as pessoas na conscientização dos direitos do titular de dados, da importância que o assunto tem para a sociedade. É fundamental, então, esses eventos. A NPD, por ter apenas 6 meses, nós temos participado ao máximo dos eventos. Queremos que todos nos conheçam, todos vejam a nossa atuação no cenário brasileiro, mesmo com o pouco tempo que a autoridade tem de vida, de criação. Então, muito obrigado por essa participação. Parabenizo a Boiana pelas palavras iniciais, a você, Laura, e estamos querendo, praticamente 20 minutos, conversar bastante e posicionar a quem está nos assistindo o que é a Autoridade Nacional de Proteção de Dados, o que já fizemos, discutimos um pouco sobre nossa agenda regulatória e as prioridades que temos a partir de então. Cumprimentar também a todos que nos assistem, e já nos colocarmos à disposição para qualquer dúvida. Nós temos nosso site, nossa ouvidoria, estamos prontos para dialogar, acho muito importante. O que é a Autoridade Nacional de Proteção de Dados neste momento? Nós, após a aprovação da LGPD, onde existia a figura de uma autoridade que iria normatizar vários pontos da lei, onde iria trabalhar em termos de fiscalização, de fazer com que a LGPD seja cumprida em benefício dos titulares. Então, nós fomos criados após um processo que passou pelo Senado, uma aprovação em plenário e, a seguir, a publicação da nomeação, em que é o momento que a autoridade é criada. O mundo passa por um período crítico com essa pandemia e nós não temos como ser diferente, nós sentimos bastante este fato e tem um reflexo grande na autoridade, que é não ter aumento de despesas. Mas eu achei espetacular o momento que foi criado. Nós temos uma forma de ganhar em várias medidas que têm sido já executada. Então, se adiasse, vamos dizer, esta criação da NPD, eu acho que seria bastante prejudicial, tendo em vista que vários pontos são necessários, vários pontos implicam em tempos, e nós estamos ganhando esse tempo, e eu acho que todos são testemunhas da produtividade que a autoridade já conseguiu nesse pequeno espaço. Nós montamos um time bastante eficiente, competente e com uma empolgação especial em cima de um quadro que nos foi apresentado de 36 pessoas que tocariam a autoridade neste primeiro momento. Então, a nossa Constituição ela é bastante enxuta. Todo órgão que inicia suas atividades, ele necessita de um tempo de maturação, um tempo de estruturação, um tempo maior de capacitação. Nós não somos diferentes, não nascemos já com os 18 anos, mas queremos rapidamente atingir esta maturidade em prol de todos. Então, vamos dizer, nós já montamos várias ações, como a nossa agenda regulatória, como o nosso regimento interno, que são ações que normalmente se levaria algum tempo. Para isso, nós resolvemos fazê-lo de uma forma bastante responsável e ganhando celeridade. Como que nós fizemos estes ganhos? Nós buscamos bons exemplos. Nós buscamos as nossas agências reguladoras no Brasil. Nessas conversas, nós vimos qual eram experiências boas e até ruins, para não repeti-las, o que nós poderíamos adaptar para a nossa autoridade. Fizemos a nossa seleção de pessoal até baseado nesse expertise, buscamos pessoas já que trabalhavam nestas áreas, nas diversas agências. Após isto, selecionamos já sistemas que nós poderíamos, com uma pequena e rápida adaptação, utilizarmos. Por isso que nós já temos um site, nós já temos a nossa ouvidoria trabalhando em sua plenitude, no momento, apenas com 2 pessoas, mas nem por isso estamos deixando de atender as diversas e muitas demandas que temos recebido. Já temos, vamos dizer, a nossa estruturação física inicial e paralelo a tudo isto, posso afirmar que estamos trabalhando numa estrutura mais robusta, mais compatível com o desafio, com o tamanho do nosso país. Com 36 pessoas e dados pessoais envolve a todos os nossos brasileiros, então é um encargo bastante grande, bastante relevante. Para isso, nós vemos que teremos que, conforme a própria lei já nos coloca, em até 2 anos, aumentar o nosso quadro de pessoal, aumentar essa nossa estrutura para atender de forma mais adequada e com maior celeridade ao que nos for enviado. Partir do zero sempre é um desafio diferente. Eu venho, por exemplo, a minha última função no governo foi a presidência da Telebrás. Você chega numa empresa, você vê o momento atual que a empresa está atravessando, qual que é a sua dimensão, quais são as vantagens e desvantagens em relação ao mercado, realinha e segue em frente. Quando você sai do zero, você sai realmente do zero. Você não tem nenhum vício, mas você também tem que tomar todos os procedimentos. É algo mais desafiador, é algo, muitas vezes, até assustador, porque nos falta alguma referência, algum exemplo anterior. Mas é uma forma até de se passar para a história, uma forma de se contribuir com a proteção dos nossos brasileiros em relação à proteção de dados. Era algo que vários países já estavam fazendo de uma forma bastante eficiente e nós iniciamos em 2020. Assim como nós buscamos com as agências reguladoras, também tivemos um grande apoio do mercado internacional. Então, a nossa LGPD ela é bastante inspirada na lei europeia. Então, vamos dizer, tivemos apoio de várias autoridades do continente europeu, Reino Unido, dos Estados Unidos, até mesmo aqui sul-americano. Então, vamos dizer, só temos a agradecer este apoio, esse diálogo que é muito importante, aonde nós vimos como cada autoridade procedeu. Isso era fundamental para os nossos primeiros passos. Capacitação foi outra preocupação, também já iniciamos de uma forma bastante eficiente, bastante feliz. Fizemos há pouco cursos dedicados às autoridades que nos foi gentilmente oferecido pela comunidade europeia. Na nossa Constituição, desafios são imensos. Vamos dizer, nós temos a nossa lei toda para ser normatizada. Quando eu falo na nossa estrutura, as diversas coordenações gerais, elas estão constituídas pelo seu coordenador geral e mais um coordenador, e falta aquele time para ser coordenado. É assim que nós sabíamos que íamos enfrentar, e é assim que nós temos enfrentados. Então, o ideal é ter tudo normatizado, o ideal é estar com a estrutura toda pronta e partir para o funcionamento, mas nós temos essa estruturação pela frente. Levantamos inicialmente o que seriam nossas tarefas, elencamos o que nós teríamos como prioridade e como possibilidade de ser executados nesses 2 primeiros anos. Então, nossa agenda regulatória ela foi baseada nisso, elencamos 10 pontos, alguns pontos já executamos, como, por exemplo, o nosso plano estratégico, nosso regimento interno. Na parte de normatização, nós elencamos nossas prioridades para esses primeiros anos. Isso não quer dizer que abandonaremos os demais pontos, isso não tem como ser feito. A NPD ela chega para que os dados sejam utilizados de uma forma responsável e não para impedir, travar, atrapalhar a transação de dados no mercado nacional. Então, nós já iniciamos algumas normatizações. A nossa normatização sempre ela tem procedimentos obrigatórios, a consulta pública, onde nós vamos ouvir toda a sociedade, as pessoas, as empresas, a nossa sociedade, os acadêmicos, isso é importante, este primeiro contato. Depois temos audiências públicas. Depois disso, culmina numa análise de impacto regulatório, ou seja, vamos analisar o que aquela regulação vai impactar o mercado, vai impactar o país. Então, neste sentido, nós já lançamos tomadas de subsídios, já recebemos, inclusive, em 2 pontos fundamentais. Um é a comunicação de qualquer evento ou incidente de dados à autoridade, isso está previsto na LGPD, mas qual a informação que deve entrar nesse comunicado, como é que é feito esse comunicado, são fatos importantes que nós vemos e era fundamental dar-se essa prioridade. A outra prioridade que nós demos já como segundo ponto foi em relação às pequenas, médias empresas, startups, empresas inovadoras, aonde muitas vezes a estrutura é bastante pequena e se nós dessemos um tratamento idêntico a uma Big Data, nós provavelmente geraríamos uma quebra, uma ruptura de várias empresas que estão iniciando de uma forma pequena, mas em breve estarão contribuindo com o país, já com uma empresa estruturada, mais robusta, atendendo às necessidades de todos. Então, lançamos também uma tomada de subsídio, recolhendo sugestões, críticas, pontos que nós teríamos que considerar numa regulamentação diferenciada para as micros e empresas de pequeno porte. Em breve já teremos, vamos dizer, alguma normatização já sendo lançada. Senhores, isso não quer dizer que o restante não é problema para nós. Por exemplo, transferência internacional, que é um dos assuntos que nós vemos que é mais complexo, já estamos trabalhando, mesmo na nossa agenda regulatória, ser um objetivo de até 2 anos, nós sabemos que não vai ser no segundo ano, no final do segundo ano, que nós vamos chegar nesse objetivo. É algo que o nosso pessoal já tem trabalhado de uma forma intensa e nós vemos que, em alguns casos, serão negociações países a países, onde cada país vai querer ter a sua garantia, vai querer ter a sua segurança jurídica para estabelecer algum acordo. Também já fizemos acordos com diversos órgãos do país, Senacom, CERT.br, tá? Nós estamos nos finalmente para firmar acordo, já estamos também em fase final com o CAD, Ministério Público. Então, o nosso objetivo é sempre estabelecer uma rede mais ampla, uma rede mais abrangente, onde possamos agilizar a troca de informações e, de uma forma coordenada, obter melhores resultados. Exemplo disto foi nessa última semana, onde 4 órgãos do governo negociaram uma solução com o WhatsApp, onde nós estamos ganhando tempo para quem ainda não se decidiu, e nesse tempo, sem nenhum prejuízo ao usuário, a autoridade, o Senacom, o CAD, o Ministério Público, continuarão nas suas tratativas junto às empresas WhatsApp e Facebook. Então, são práticas boas que nós entendemos que, vamos dizer, não só as empresas, mas a sociedade também é beneficiada nessa ação, onde os órgãos correlatos estão atuando de uma forma coordenada, de uma forma mais segura para todos. A autoridade, ela, na parte de fiscalização, nós sabemos que, pela lei geral, nós só colocaremos sanções a partir de 1º de agosto, mas o nosso recado sempre em painéis, em conversas com as empresas, é que nós sabemos da complexidade da lei, sabemos da falta de cultura que o Brasil possui no tema proteção de dados, e temos como principal objetivo a orientação, como principal objetivo a educação, culminando na cultura. O titular de dados é o foco da autoridade. A autoridade ela veio para dar segurança, para dar proteção, para garantir que os titulares tenham os seus direitos respeitados, mas nós entendemos que sanção apenas não vai resolver o problema. Nós temos que conversar bastante, nós temos que dialogar com todas as sociedades, empresas, mostrar que é importante esse respeito ao titular de dados. A empresa não deve encarar como uma despesa, mas sim como um investimento, e estabelecendo boas práticas, estabelecendo, vamos dizer, uma política de governança bem apropriada, nós teremos uma LGPD implantada de uma forma bem responsável, bem transparente, e é isto que a autoridade tem feito nestes 6 primeiros meses. Sabemos que o nosso desafio é imenso, sabemos o tamanho da nossa responsabilidade neste assunto, mas estamos contribuindo de uma forma bastante rápida em prol de estabelecer todas essas ações tão importantes para o nosso cenário nacional, sempre com bastante interação, bastante integração com as diversas autoridades, com diversos órgãos no país, e nos colocando bem transparente, bem receptivo, através de nossos sites, de nossos links que estabelecemos de conversação com todos. O meu tempo praticamente está esgotado, então agradeço mais uma vez esta oportunidade e me coloco à disposição. Sei que não teremos muito tempo para isso, mas qualquer questionamento podem direcionar ao nosso site, aos nossos e-mails, que responderemos de uma forma bastante rápida. Obrigado, Laura, obrigado, Boiana, obrigado a todos, e que tenhamos um belíssimo evento com grandes apresentações, grandes trocas de ideias e grandes debates. Obrigado.
Thank you, Waldemar, very much for that fantastic opening of our global dialogue. First of all, I want to personally congratulate you and the other colleagues, directors of the IMPD for mobilizing so quickly the agency, for publishing, being transparent, and for publishing the regulatory strategy and priorities. It's incredibly important for people and companies in Brazil to understand where your priorities are. And I also want to congratulate you for being so open and always ready to engage. You know, we have been on a number of webinars already with a number of directors and yourself, and it really is excellent to see. My second very quick comment is I'm so grateful that you have said two things. One, you have said sanctions alone will not change and create the culture of data protection in Brazil. And that is so important. We need to explain why this is good for people and businesses. And you have said businesses must not see this as a cost, but as an investment. And I'm absolutely with you there. I absolutely agree. That's the way to approach as well. So I hope businesses are listening to what you're saying as well. And we look forward to working with you on this project and the agency as well. Thank you very much. And I would now like to introduce our second keynote speaker, somebody I've known for many years, Simon McDougall, who is Executive Director, Technology Policy Innovation and Deputy Commissioner at the UK Information Commissioner's Office. Simon is standing in actually for Elizabeth Denham, who the last moment had a clash and she could not join us, but we couldn't be in better hands with Simon. As you know, UK holds the Global Privacy Assembly chairmanship. Simon in particular has been brought in from his incredible experience in private sector and consulting in private sector for many years to work with the ICO for the past 2 years. And Simon, we are absolutely delighted to have you here and hear to hear from you and about your and UK ICO's perspective on where we are in this data privacy world, where the trends are going, what's the UK's role there, how do we work all together, what can we learn from amazing UK ICO's experience. So Simon, thank you very much. Maybe we can leave a couple of minutes for questions. If anybody has questions for Simon, please send them through the chat, but otherwise I may have something as well. Simon, thank you very much, and please, the floor is yours.
Liana, thank you, and thank you for your kind words. And thanks to CIPL and to the CEDIS IEDP for organising this excellent event. And thanks to our colleagues at the INPD and our friends across the privacy community for taking the time to listen to this address. So I'm delighted to be speaking with you today. And Liana, as you said, Elizabeth sends her apologies. It really was quite unavoidable that she couldn't make this date. I've been asked to speak about global and UK perspectives on data protection. And the first thing I want to do is just step back and admire the vastness of this subject, of the challenges that we are facing as data protection authorities. And as I think about the breadth of what we are facing, sadly, my thoughts and our lessons first turn to what we have learned from the COVID pandemic in the last year, well, more than a year now, isn't it? In the last year and a half or so. COVID has both accelerated the change in how data is used, and I think made clear to all of us how much power resides with whichever organization has the data, whichever organization controls the data. We are dealing with power and imbalances of power here. On the other hand, with COVID, we have seen a huge amount of innovation, and I think we now better understand as data protection authorities how fundamental public trust is to any new initiative, any new project that a government or a health authority or any organization wants to undertake. So in the UK, we've seen that manifest itself through questions around how data is used in our test and trace system. A particular incident we had last year in terms of how algorithms were being used to determine exam results, or right now in terms of the public debate on how health certificates, vaccine passports may enable people to use goods and services in the future. So we're really seeing that it's a very dynamic situation for us, and we've seen, you know, at the same time, as well as having concern around public trust, we've seen innovation in how health data has been used to understand the nature of the virus. And in the UK right now, data is being used very effectively to help accelerate our vaccination program. So we're seeing both the good and bad sides of better data usage. But effectively, every aspect of our world has changed through COVID. And I think we can now much more clearly see than perhaps we could at the beginning of last year, how much data permeates our everyday lives. Now, this is not surprising for this community of data protection regulators and practitioners, the people at this event. We've known for years and years that there's an increasing amount of data being produced in the modern world, and more of that data is being linked to people. But I think a lot of our stakeholders have now woken up to this, because COVID has both fueled and accelerated these trends and really made stark the fact that we live in a data saturated, personalized world. So I'm trying to think about what that means for data protection authorities. I think firstly, we just have to accept that we're working on a very broad waterfront. We've had some new joiners at the ICO recently at the executive level and the director level. And all of them have said to me along the way how surprised they are, even though they knew the ICO from the outside, quite how much stuff, how many issues we are dealing with. It's a very broad waterfront. And this is exciting, but in a world where every service is data driven, there is a risk that a data protection regulator accidentally becomes the regulator of everything. And by becoming the regulator of everything, we risk becoming the regulator of nothing, becoming too widely spread and having always challenge on what our scope is. So what do we prioritize in this world? I think there are three areas to consider here. Firstly, I want to pick up on the Director President's excellent words this morning about prioritization and the clear vision and excellent outline of the priorities of the Unpaid Day that he outlined. I think one comment we've had as a long-running data protection regulator is it's very hard to maintain that focus and that prioritization as the real world comes at you quickly. There are always incidents and complaints and press stories and politicians who raise a particular issue. And so to maintain clarity and make sure that your impact doesn't get diluted is an ongoing operational challenge. So maintaining priority is my first message there. I think that is key. I note, Biana, that following me, we have a panel with an excellent range of speakers that is talking about prioritization, risk management and outcomes. I think that's a great thing to start this two-day event with. I think secondly, a modern data protection authority needs to have a cross-disciplinary perspective to participate in this very complicated landscape. And it needs the skills to match. Sometimes the skills within the organization, and I keep in mind here that the UNDP has 36 people right now, but it's also having access to skills elsewhere in terms of colleagues and friends and consultants, etc., etc. And I think that is the nature of modern data protection. We need to understand the law, but we also need to understand policy and technology and economics and the sociological impact of data usage. All these things are very much intertwined right now. So data protection is becoming much more of an applied science. We are having to, we have our principles, we have the statute, these things are important. We have great communities in terms of the practitioners on this call, academia, civil society, But the data protection authorities also have to work in the real world, which is fast moving, it's messy, it's iterative. So we need to have the skills within our organization to make sure that as we act and we intervene and we try and adjust and affect and change the world we live in, we have the full range of skills to understand what we're doing and respond appropriately. So broad skill sets are important. Continual engagement is also important. Thirdly, in terms of how we manage this new world, I think a data protection authority has to be connected to the full range of consequences that the processing of data has. Now, this can be challenging because every data protection authority, and indeed every regulator around the world, is primarily a creature of statute. We have been set up by legislation. Often over time, we pick up other bits of legislation. The ICO has, it's either 10 or 11 pieces of legislation which we work to. And I've learned through engagement with other UK regulators that every other UK regulator is in a very similar situation. If you exist for a period of time, then people just give you other things to do along the way. So we have to work within that statute. And if we don't work in that statute, then quite rightly, we'll be challenged in court, we'll be challenged by government, we'll be challenged by advocates and civil society, because we have to work within our own bounds. That all said, I think there needs to be some consideration of the other risks and consequences of how personal data is used. So I'm thinking here about risks that affect groups of individuals rather than individual data subjects, as would say within the UK and Europe. I'm thinking about societal harms. Even nowadays, I'm beginning to think about the environmental consequences of data processing. We've seen recently the interaction between the carbon cost of Bitcoin and the growth in cryptocurrencies, and some organizations such as Tesla shuttling forward and backwards on their policy positions. These are all things to do with data processing. I think in the UK, we've seen a bit of a change in attitude to this broader field of what you could call on some levels data ethics over the last year. I think COVID has caused people to think a bit more broadly around societal issues versus individual rights, and to be able to accept different approaches that they may have been resistant to before around areas such as health data sharing, where we've seen a lot more innovation in how health data is used compared to the pre-COVID world. I think one of the areas we are keen to emphasize at the ICO when we talk about data ethics and data protection is that we see privacy as a fundamental right, absolutely, but privacy is a fundamental right. It is not an absolute right. It has to be applied in the field. COVID has forced us to apply that principle in practice, as again and again we've had to deal with collective challenges which have involved societal goods and issues and challenges that can only be engaged with if everybody is involved in them, whilst at the same time reminding government and other stakeholders that whilst privacy is a fundamental right and not an absolute right, if public trust is lost, then the initiatives won't work. People will not participate, and therefore the attempt to bring the whole of society along with us fails. So that's quite a hard balance to strike for a data protection authority, whether it's one that has been going for a number of years or one which is relatively new into its being, is how do you balance the letter of the law against these broader consequences of data processing? Now, I'm not suggesting for a second that any data protection authority should try and own all of these data ethics issues. That's, again, beyond our statutory scope. But to pretend they don't exist, or worse, to kind of think that all these considerations have to be in conflict and in competition, that's dangerous. That misses the big picture. So there has to be a way to be engaged on this. So in summary, in terms of how to prioritize and how to operate in this complicated world, I think data protection authorities can best succeed by having clear priorities, a cross-disciplinary team, and engagement with the other consequences of processing data, as well as the immediate data protection consequences. That's what, for me, makes for an effective and strong data protection authority. But the last point I want to make, Boyana, before we move to questions, is that even then, the strongest data protection authority can only be effective in the modern digital world if it works with its fellow regulators in the digital regulatory landscape. The Director President mentioned that the INPD has already signed accords, agreements with Brazil's National Consumer Secretariat and now with the antitrust regulator as well. And they are thinking along the very similar lines to the work we are doing in the UK on this. I think that's a natural reaction. I think in the last couple of years, we've seen a collapsing of barriers between traditional regulatory silos, partly because new products and services have arisen that are driven by personalized information, and also because in some cases, very large technology firms have expanded their businesses to cover more of our everyday lives. So those two trends mean that data is driving more regulatory issues across the board, and as horizontal regulators in data protection, we need to work with sector regulators and other regulators in our countries. So in the UK, we've done this by forming a group called the Digital Regulation Cooperation Forum, the DRCF, which is formed of ourselves, Ofcom, which is the UK's communications regulator and has responsibility for online harms as the Online Safety Bill progresses through Parliament, the Competition and Markets Authority, and also the Financial Services Authority. So it's the communications regulator, the competition regulator, the financial services regulator, and the privacy regulator together. This has been on a formal setting without any statutory basis, I hasten to add. This is four regulators with their own remits working together, but still as separate regulators. But it's a staffed up team which really came into being in the middle of last year. But even that was after 2 years of very close work behind the scenes. I think it's worth noting that we all come from very different points. We have different ways of speaking about risks and harms and policy objectives. It took time for us all to understand how one another worked. We did speak to one another before the DRCF, but not on the same involved, detailed level. And it's taken time for us to really understand how one another works. You know, we at the ICO come from a rights perspective when if you talk with the CMA or Ofcom, you know, or the FCA, they're economic regulators, and they have more economists in place, and they think about things differently. So we've had to work harder on the soft side, the cultural side of how we work together. But as we've done that and we've begun to understand one another's languages and concepts better, we've realized there are real synergies in our policy objectives. And whilst we have focused our work often on where there may be differences in policy objectives, really that's the minority of areas. In the very large majority of cases, we are very much aligned. So we are working through what we can do in the new digital world. And I won't go into too much detail on our current plan because of time, but we've published our work plan. And if you Google it, you'll find it. But by all means, come to me and I will direct you in the right direction. But we published our work plan in March, and it is a detailed work plan with various staff seconded from the different organisations to work on this, covering areas such as online harms, protecting children, how we work together on regulating big technology firms, how we engage on policy matters, how we engage on technical matters such as end-to-end encryption, and really capitalising all the knowledge of all of the four members to develop coherent regulatory approaches, which mean that in the UK there is a more consistent regulatory landscape, and we are working together on issues of common interest. And I would very much recommend the work plan to the audience here, because a lot of work went into it. And I do think that in its level of detail, in the practicality of what we are trying to achieve, it is a very exciting initiative. The last thing I'd say is we are trying to run towards the challenging problems here and do real work on the challenging problems where there aren't easy answers. So for instance, on end-to-end encryption, we are interested into encryption, and privacy regulators will normally be supportive of encryption measures because it increases security, increases the privacy of communications. Obviously, online harms, content regulators often are worried about end-to-end encryption because it means the technology firms are blind to the content that is being shared on their platforms. So we have a project going with all of the DRCF members, but especially ourselves and Ofcom in this regard, looking at end-to-end encryption. The other area I'd mention is on competition and how we balance out the challenges of the pro-competition measures around sharing information in many circumstances versus concerns that data protection regulators have about data sharing measures, and in particular in how that works within advertising and how cookies are used and how ad tech is used. And this morning in the UK, so a few hours early morning Brazil time, we published a joint statement with the CMA on our views on the relationship between competition and data protection in the digital economy. And this isn't just a 2-paragraph statement saying some nice things. This is 30 pages of analysis of which has been generated by co-working between the competition regulator in the UK and the data protection regulator. And again, that's on our website right now, and we're really looking to kind of get to that next level of detail and cooperation beyond just having a goodwill and fluid ways of working. So in conclusion, we're working together on the most productive way forward for data protection authorities, but we need to collaborate closely with our peers, as we are doing today at this excellent event, but also collaborate with our fellow regulators and always challenge ourselves to see the big picture. Data protection is going to remain a vast subject, but it's one that we can regulate effectively and efficiently with a little help from our friends. So this event is a step along that path, and I'm sure we will learn a huge amount from the next 2 days. Thank you.
Simon, thank you so much. That was riveting and inspirational as well. All I can say is you talked about 3 particular priorities that DPA must prioritize, first of all, within its own work, cross-disciplinary, have a cross-disciplinary perspective and have a bigger picture. And I can't help but notice that when you think about the data protection officers, and I know in your previous role you worked with chief privacy officers, that's exactly what we have to do as well on the data protection in-house side. We must prioritize our compliance activities based on risk. We must absolutely have cross-disciplinary knowledge. Lawyers are not going to solve protection and create culture, as Waldemar talked about. We need engineers and user experience people and marketeers and public relations people, as well as of course, data scientists. And then last point, having that bigger picture. I mean, for internally as well, companies are now starting to think about general data policy as well as bigger picture risks like societal risks and harms. Simon, thank you for also very much kind of explaining how ICO is in the forefront of new things. And I think the work that you're doing in terms of cooperation and collaboration with other regulators is really unique, and we haven't seen anything like that around the world. So there has to be great practice for everybody to follow. I know this is something that we will talk more in Brazil, and in Brazil there is this need also to pull together a number of regulators, but in other countries as well. This really is a key topic. I would like to actually ask a question or two, if I can, that have come from the chat. The first one was from Camilla Castiglioni, who asks, could you comment on the challenges faced towards health data sharing in the UK, considering GDPR? And maybe Simon, while you are at GDPR, could you kind of tell us a little bit about the UK's direction post-Brexit and post-GDPR? Well, not post-GDPR, with GDPR, but post-Brexit.
Sure. So great question on health data sharing. And I've been the accountable executive at the ICO on all of our COVID response. So that's been really the main part of my day job over the last year and a bit, which obviously has been both very challenging, but also very rewarding, because it's been, you know, a very critical area of every country's COVID response. I think one of the interesting things in the UK, and I don't know, Bjorn, how much this translates to Brazil or around the world, but one of the interesting challenges with health data sharing in the UK is that very often we found that GDPR was not the main restrictor for health data sharing. And that's a very particular point to the health sector. So in the UK, we have something called the common law duty of confidentiality. Effectively, this is medical confidentiality. This goes back to medical ethics and the fact that your doctor has ethical obligations not to go and tell everybody down the pub or about your medical conditions. And obviously, that's been a concept that's been around for hundreds and hundreds of years in different forms. But that has, in the UK, various applications in case law, and there are various codes of practice and various cultural issues as well in terms of how different medical practitioners understand medical confidentiality. And so when we've looked at issues around health data sharing in the UK, whether it's for primary care when people are actually ill, or whether it's for research purposes as well, which is also incredibly important, what we've found is that it's a multi-layered challenge. And you have issues around legacy infrastructure. One fact that is often mentioned is that the UK's National Health Service remains the largest purchaser of fax machines in the UK. We have on one hand space age technology, on the other hand a lot of old technology within our National Health Service. So you have issues with that, you have these cultural issues, you have medical confidentiality issues, and then actually, given how hard those problems are, the gateways that exist within what is now the UK GDPR, of course, are actually work fairly well. They're not perfect, and it may be an area where there is some reform over time, but they're not the main reason why these issues aren't being solved. Now, what we have seen within COVID is that there has been progress. Some of those barriers have been broken down because some of those barriers break down more easily in a crisis. So the challenge for the UK right now is how do we move into a post-COVID world, hopefully over time, and obviously right now the world's still in a very bad place. How do we move to a post-COVID world and retain the innovation around health data without going back to bad habits? And that's obviously a big challenge. As to your broader question around UK GDPR and where the UK goes from here, that's at one level that's up for government to decide. I mean, obviously, there's the ongoing dynamic around adequacy and essential equivalence, and the UK government has been very clear that it wishes to maintain high standards of data protection in the UK, and that's part of its vision for a post-Brexit UK. And at the same time, the Secretary of State has said in various articles that the UK government is open to reform that maintains those high standards. So that's something which, as a regulator, we look to respond to. It's up for UK government to set policy and go from there. But it'll be something which government will doubtless carry on looking at through its national data strategy, its digital strategy over the next few months and years.
Simon, thank you so much. And I wish we could ask more, but we really have to move on with the rest of the panel. I hope you're able to stay with us a bit more, perhaps to listen to the next panel. And we will try to answer the questions, if we can, later on as well, that other people have asked. But Simon, thank you so much. And we look forward to hearing more and working with UK, of course. And now I would like to pass the floor to my very good friend and colleague, Richard Thomas, who actually is a global advisor to us at CIPL, but he, of course, was the Information Commissioner at UK, and he's also the chair of the Guernsey Data Protection Authority. And I've asked Richard to moderate this panel now with a number of leading data protection regulators and experts on, what does it make for effective, forward-thinking, risk-based and outcome-based regulators. So Richard, over to you. Thank you, everybody, very much.
Thank you very much, Bojana. Particular greetings. I start with our colleagues at the APND. You're probably the youngest data protection authority in the world. As Bojana mentioned, I was the UK Information Commissioner. I'm now pleased to be an advisor to CIPL. I'm also the very part-time chairman of probably the smallest DPA in the world, the island of Guernsey in the English Channel, a very part-time chairman there. I'm also the main author of the CIPL discussion paper, Regulating for Results, which was published 3 or 4 years ago. And in 3 or 4 minutes, I'll just try quickly to introduce this panel by summarizing what we said in that paper. We said there that all DPAs have 2 fundamental features. They have numerous functions and responsibilities, and they have inadequate resources. They also have perhaps a third feature. A single fundamental challenge for any data protection authority is how to be effective. And that in turn raises questions. What objectives? What strategies? What outcomes? What priorities? In other words, do we really know what we mean by what is it to be effective? In our paper 3 or 4 years ago, we tried to help answer this question by reminding people that there are 3 main types of function for any data protection authority. One is to be a police officer, investigating non-compliance, imposing punishments, compelling changes of behavior, the policeman role. Secondly, to be a teacher or a leader, to educate organizations about their responsibilities, to help them get it right with data protection. And also, of course, educating the population at large, individuals, about their rights. So as a teacher, as a leader, you are the voice of authority. And the third function is to be an ombudsman, to deal with complaints, investigating, and if need be, upholding individuals' rights. Well, of course, within those 3 categories are very many more detailed functions. But on top of that, any data protection authority is regulating so many activities. The digital economy, as we've heard already this afternoon, stretches across the whole of the public and the private sectors. The phrase has been used today, data never sleeps. As AMPD director said, if you regulate everything, you regulate nothing. And certainly one of the messages of our paper is that a DPA cannot do everything. A phrase I've used many times is you have to be selective to be effective, with a focus on outcomes, a focus on the results that you select because those are the ones you want to achieve. Of the 3 categories in our paper, we said that perhaps the complaints handling function, the ombudsman function, should be the lowest priority or the least effective. You cannot control the demand. You can't easily control the flow of complaints coming into the organization. They can very quickly become very demanding. They are very resource intensive, very resource hungry, and they can distract from other functions. Of course, there is a value in complaints because they can be a very important source of intelligence to tell the DPA what's actually happening out there in the marketplace. The policeman role is also very resource intensive. It can be very adversarial, it can be very legalistic, organizations can get very defensive, and it doesn't always lead to improvements in behavior. And indeed, there is some increasing evidence now that punishment has only a limited role in deterring bad behavior from other organizations. And as we already heard today, someone said that sanctions alone are very rarely enough. So in our paper, we suggested that the teacher role, the leader role, is or should be the top priority, and particularly constructive engagement with the regulated community. The truth is that most organizations want to get it right. It's a matter of enlightened self-interest, and helping organizations get it right can be a very important priority for a data protection authority. Sometimes perhaps that is the least glamorous, but we would argue perhaps it is the most effective. But these are simply the views we expressed in our paper. That's all I'm going to say now. What's really important today is what our panelists have to say in response to these issues. So a very warm welcome to our 6 panelists. I will introduce them as we go on to the questions in a moment. They've all been given some specific questions, but more generally, We want them to indicate whether they agree or disagree with the approach I've summarized, to find out what they think, to find out how they're doing things smartly or effectively inside their own organizations. And as they go through, if you would like to answer any questions, time will be very tight, but please type your questions into the Q&A box. So we're going to start with the same couple of questions for 4 of our panelists. The 4 are Arthur Sabat, who is a director of ANPD, Anna Morgan from the Irish Data Protection Commission, where she is Deputy Commissioner, from Zikan Young, who is the Assistant Chief Executive of the Personal Data Protection Commission in Singapore, and to Guilherme Roschke from the Office for International Affairs at the Federal Trade Commission in Washington. We've got a truly global panel, and the questions for the 4 of you, starting with Arthur, your same questions. How does your data protection authority prioritize its activities to achieve the best outcomes? And what have been the biggest challenges when applying an outcomes-based approach? And how have you addressed these challenges? So those are the questions for our first 4 panelists. Over to you, Arthur.
Muito obrigado, professor Richard Thomas. Muito obrigado a todos que nos acompanham. Essa é uma pergunta excelente. Como priorizar, né? Bem, nós procuramos fazer isso desde o início. A nossa autoridade ela é muito jovem, como o professor falou, é muito jovem, e nós procuramos, numa nossa primeira decisão como conselho diretor constituído, aqueles 5 diretores, foi de estabelecer uma agenda regulatória. Porque quando nós lemos a nossa Lei Geral de Proteção de Dados Pessoais, ela aponta para aproximadamente 65 temas que merecem uma regulamentação por parte da autoridade. E aí nós fizemos uma agenda regulatória com essas primeiras ações, primeiras 10 ações, que vão ser regulamentadas por nós nos próximos 2 anos. E o que nós levamos em consideração para priorizar esses temas? Foi exatamente o potencial de impacto da regulamentação desses temas e da necessidade desses temas para a sociedade, para as instituições públicas e privadas e para o indivíduo, né? Então, quando se elabora uma regulamentação, e aí nós temos que pensar exatamente nesse impacto e no que ele vai trazer de benefícios, no que aquela regulamentação vai trazer de benefícios para a sociedade, para todos aqueles setores, para todos aqueles indivíduos. Então, como que eles vão se beneficiar? Que impacto que vai trazer sobre a vida deles no dia a dia? Como aqueles direitos desses titulares eles serão mais respeitados, né? Então, foi isso que nós passamos nós pensamos, e aí colocamos isso na nossa agenda regulatória, né? Agora, é claro que devido aos mecanismos de aprovação de uma norma pela autoridade, isso aí é muito da legislação brasileira, então nós conseguimos somente colocar 10 nessa agenda. Não colocamos mais por conta dos prazos legais que uma regulamentação possui no nosso ordenamento jurídico, brasileiro, né? Então, eu acredito que, por enquanto, seja isso, professor. Muito obrigado.
Well, thank you very much, Arthur. It's a very concise summary of how in just a very short time you already began to identify priorities in terms of impact and also working within the law you have to administer. The same questions perhaps now to Anna Morgan, the Deputy Commissioner in the Republic of Ireland.
Thanks, Richard, for the introduction, and indeed thanks for the invitation to speak with you all today on this really important topic of regulatory priorities. I think the first thing to say is that this is actually quite a timely discussion for the Irish Data Protection Commission, given that we have in the last couple of weeks published our own draft regulatory strategy, which is out for consultation until the end of June. And I'll give it a bit of a plug by saying we really do encourage comments and responses from the whole spectrum of our stakeholders on this document and the positions that we've set out in it, which I'm going to briefly mention in my comments today. So I think at the core of today's discussion is the reality that data protection regulators are juggling with very many competing demands across a vast range of areas, and really trying to figure out where a fair balance lies in weighing up opposing interests and deciding how to make the best use of their finite resources. So first and foremost, one of the most critical, and I think perhaps even the most existential questions for the DPC as an EU supervisory authority regulating as we do under the GDPR is how to balance our individual complaint handling obligations against the need to address high risk systemic issues that are posed by large scale data processing, whether that's occurring in the digital sector or indeed in the public and government sector. So under the GDPR, we must, of course, handle and investigate to the extent appropriate every single complaint that we receive, because data subjects have a right under the GDPR to lodge a complaint with a supervisory authority and to have it handled and to receive updates on its progress every 3 months. And of course, they have a judicial remedy that lies against a supervisory authority where it fails to do that. So I suppose just giving some metrics to kind of bring that obligation into kind of real life terms. In the first 2 years of regulating under the GDPR, so between May 2018 and May 2020, the DPC received in excess of 80,000 contacts to our office. And in foot of those, we opened around 15,000 cases on behalf of individuals. And I think the thing that's really struck us about our analysis of those statistics is that the vast majority of these cases were narrow in scope. They involved just one individual and they centered on issues that have no major or lasting impact on the rights and freedoms of individuals generally. In fact, that kind of chimes with a lot of the complaints that we see, which relate mostly to conflicts that have arisen in areas like an employment relationship or a service provider and customer relationship, even insolvency related actions, or perhaps even things like disputes, interpersonal disputes between, say, neighbours over domestic CCTV. So having to individually investigate and resolve each such complaint is, of course, resource intensive. And while we at the DPC might reach an outcome for that individual, which is positive for them, in the vast majority of cases, there isn't a broader, more systemic impact, which improves the position of a wider cohort of people. So I suppose then to go back to the theme of competing demands and regulatory challenges, which is what we're talking about today. On the one hand, at the DPC, we have thousands of individual specific cases that we must deal with. And then on the other hand, there are those endemic and systemic risk issues in the processing operations of big tech and digital operators, which are established in Ireland and for which the DPC is the lead supervisory authority under the GDPR. And the processing operations of those organisations affect potentially hundreds of millions of people across the EU. So the very big question for the DPC is how to balance oversight of those organisations against the resources required for handling vast volumes of incoming individual complaints. And then, of course, added into the mix is the DPC's critical mandate under the GDPR, as other EU regulators have, in receiving and assessing breach notifications, which must be made on a mandatory basis and which continue to increase for us year on year, with more than 6,600 breaches notified to us in 2020. And of course, nowhere near all of those cases can be turned into formal investigations. So we must by necessity take a risk-based approach to identifying those data breaches that pose the greatest potential harm to data subjects based on severity and volumes of individuals potentially affected. So the DPC wants to achieve as much as possible for as many people as possible. And that includes not only the many thousands of individuals who contact us directly, but also the many millions of people who do not, but whose rights may have been infringed by circumstance. And in order to do this efficiently and effectively, as we see it, the DPC needs to rebalance the way it approaches individual complaints to ensure that its resources are being used in the most efficient way possible to bring improved results to maximum amounts of people. So in other words, by prioritising cases that are likely to have the greatest systemic impact, for the widest number of people over the longer term, and to allocate our investigative and our enforcement resources on that basis. But of course, then the question still remains as to how to enable individuals to vindicate their data protection rights in each of those individual cases, which are frequently of central significance to those people in their own lives, and we must pay heed to that. And so the feedback that we have seen from conducting focus group consultations with individuals over the course of our engagement in building our regulatory strategy in recent years, that shows a sense of frustration or undue burden amongst individuals who generally feel that businesses and organisations were essentially divesting themselves of data protection accountability and passing it on to customers and consumers. So tackling this lack of control experienced by individuals and potentially the lack of accountability by organisations boils down to, I suppose, a two-pronged approach. Firstly, supporting greater empowerment of individuals, and then secondly, driving ever greater accountability from organisations. So taking first that sense of lack of control, stakeholder feedback that we have received from individuals indicates that what they really seek is greater understanding of their rights and entitlements so that they can empower themselves, so that they can identify reputable organisations and conduct their own transactions with confidence. And at the DPC, we consider it critical to allocate resources to the systemic areas which can do the most good, such as in this case, educating individuals so that they have a better understanding of their data protection rights, so that they know how to exercise those rights on their own behalf, and then they know how to escalate their issues to the DPC when necessary. And we believe that that in turn will help us to turn away from a complaint-heavy system, which is neither expedient nor beneficial for the majority of data subjects. And I think at this point, it is really important to emphasise that the DPC is not looking for ways to dismiss complaints, because data protection is, of course, an EU Charter protected fundamental right, and the entitlement to make a complaint to a supervisory authority is enshrined in the GDPR. But what we are trying to do is find a more effective way of handling the extremely high volumes of complaints that we receive annually, and to do so in a way that benefits the greatest majority of people. So then on the second issue that I mentioned of organisational compliance and accountability, while we recognise that most businesses and organisations are keen to meet their obligations under the GDPR, they sometimes lack clarity about how those obligations are best operationalised. And so in this vein, the DPC is continuing to support data controllers in their compliance efforts so that current and future businesses have clear guidance on incorporating data protection into their practices. And we believe that increased and informed compliance will in turn have the effect of mitigating potential harms to individuals before they occur. And of course, that all accords with the DPC's mandate to safeguard individual rights. So all of that brings me to another issue that I suspect will be central to today's discussion, and that's around competing regulatory approaches of hard enforcement versus guidance, engagement and supervision of organisations. And of course, the latter are frequently seen as the softer, the less effective tools for regulators. And with the advent of the GDPR, I think that there has been an ever-growing tendency to conflate administrative fining in particular with regulatory success, and to use the imposition of fines as a means to measure effectiveness. And we've seen a divergence of stakeholder opinion in our own outreach on this issue, from at one end of the spectrum, a very low tolerance of infringements and calls for immediate fining on the basis of infringements, to then, on the other hand, industry calls for a more risk-based approach so that only instances of willful negligence or deliberate infringements will be punished more severely. So the so-called hard enforcement options and sanctions are, of course, tools that are at the disposal of the regulator, but they're not the limit of their regulatory role. And that extends beyond the application of penalties to include changing cultural approaches to data protection for the benefit of society as a whole. And we believe that that's done by extensive engagement, which, contrary to what some commentators might argue, is not indicative of an unwillingness to regulate, but rather it's a recognition that investing time and effort into developing a culture of compliance will ultimately drive data protection efficacy. However, of course, that said, in parallel to those sorts of supports for organisations and in line with that risk-based approach to the GDPR, the DPC will also punish those entities who infringe data protection law, and will do so in a way that, as required by the GDPR, is effective, proportionate and dissuasive. And we consider that a balanced combination of these harder and softer regulatory approaches will further reinforce the fundamental importance of accountability for data controllers under the GDPR. So to sum up, and I hope I haven't gone over time, the GDPR is a risk-based instrument, and the DPC considers that this calls for a risk-based approach to harm as one of the cornerstones to our regulatory priorities. And our guiding objective in balancing these challenges of the very many competing demands in the data protection landscape is to ensure that our resources are always prioritised on the basis of delivering the greatest benefit to the maximum number of people.
Anna, thank you very much. You kept well to time. Some really interesting points you made there. I picked up the importance of empowerment, accountability, and your last point, almost are fines a sign of success or perhaps even a sign of failure? That's for discussion as we move forward. But let's go straight to Singapore. And I hope we're joined by Seekin Yong, who's the Assistant Chief Executive of the Singapore Personal Data Protection Commission. Are you with us, sir?
Yes, yes, yeah, thank you.
Hello, good.
Yeah,
you have any questions, I hope. Over to you.
Yeah, thank you for the opportunity to share some thoughts from this part of the world. I do think that I might have a slightly easier job in the sense that enshrined in the purpose clause of the Personal Data Protection Act, right, is the Northern Star for us. It establishes two things that we are supposed to do. It is one of it is to ensure that the consumers' expectations and right for their personal data to be protected. That's one of our objective. The second is to ensure that organizations can continue to have legitimate use, right, of personal data. So it's a set of guardrails that kind of like helps us decide, right, how to organize ourselves. So one of the things that we have discovered over the last 2-3 years, right, is that as was said earlier, big fines, enforcement, investigations, those come too late. We have to take this message upstream, and that's one of the things that we did about 3 years or so ago. One of the key things we did as we went back to our roots of accountability was to take the message to the board of directors. We worked with the Singapore Institute of Directors. That's the body in Singapore that kind of sets the corporate governance practices and the best practices for companies. And they publish a corporate governance handbook that all directors use as their Bible to organize themselves. And we worked with them, and we launched data protection as one of the things that the board needs to pay attention to as part of risk, right? As part of risk management. And the second message that we brought to the board was that if you believe that data is the new oil, then you need to do a few things. You need to, one, invest to improve the quality of data. Second, you need to know how to make use of data. And third, you need to know how to protect, right, and ensure that value is safeguarded. And the best way to get this done is appoint the right check to help you do it. So the data protection officer, we tell the board, right, should be appointed from amongst the senior management or have a direct line to the senior management. By lodging, we believe that by lodging data protection as something that the board should pay attention to, and by having someone who is in charge at that level of seniority, everything else will fall into place. So the next thing that we try to do with the companies, right, is to really share with them accountability tools, how to put those practices in place. But key amongst that is to make sure that we recognize and reward companies who have good accountable practices. How do we do that? One, we introduced a certification system. We have a data protection trust mark, a badge of recognition that companies with good practices can go for. We complement that with enforcement policies, enforcement and mechanisms like the statutory undertaking, like an expedited breach decision procedure, so that when accountable organizations want to be have these practices in place, they are able to come to us and say that we've got this drawer plans, we are ready to execute. Can I give you an undertaking, and can you give us time to execute our plans, because we know what needs to be done, and we've got robust plans. And one of the things that we realize is that sometimes companies are very cagey when speaking to the regulator. They use guarded language because they need to safeguard their commercial interests. So we introduce an expedited breach procedure so that they can very quickly come to us and admit a breach. And in that way, when they make statements to us, it can be open, it can be full and frank, and they don't have to worry about the other commercial interests because they've made all these declarations. So embedding accountability into policies and recognizing them through a certification system and supporting it through enforcement policies is another important thing that we do to make sure that companies are incentivized to do the right thing. One of the things that we are starting right now is to see how can we help other companies who may not have this level of expertise. Not every company will be able to appoint a full-time data protection officer or a data protection officer with the right level of training and expertise. So for the vast majority of companies, what we try to do is really to simplify what needs to be done as data protection practices, translate them into things that they can do, and embed these actions into their into their ordinary business processes. This is the way we are hoping that we can reach out and help more of the companies. The way I describe it is that data protection practices must be like the reinforcement bars in your walls and in your pillars and in your floors. They are there because without them, the concrete is weak. But with them, your concrete is much stronger and you can build skyscrapers. So that's how I see the need for data protection practices. Embedded, not necessarily front and center in your face, but they will be there, and if they're missing, you will know the consequences. So we believe that going upstream, getting these practices into companies, recognizing those with good practices, is going to be a lot more helpful than emphasizing enforcement. And accountable companies will also be able to build consumer trust because they will then have good reputation, right? And we hope that by doing so, companies based out of Singapore will have a good reputation globally as well. But having said all that, we cannot forget that in the suitable case, when the case calls for it, there is always the need for retributive justice and general deterrence. So the enforcement arm needs to be flexed once in a while, very strategically, just to make as a gentle reminder, so to speak, right? And I just end off by saying that while we go upstream and we believe a lot can be done to help companies, the other set of constituents we reach out to a lot are also consumers. With very clear messages, very simple things for them to do so that they can keep themselves safe, avoid places of danger, adopt good practices. I think I'll just stop here and be happy to share a bit more in subsequent panel discussion. Thank you.
Zakin, thank you very much. It's very late at night for you, I think, but you've given us a very graphic image of the data protection being the reinforcement of the concrete building of an organization. And I think you made very important points also about the importance of simplifying the requirements so that organizations can understand what they're supposed to do in the real world, and also giving incentives to do the right thing. I think that's very important. We know that Singapore is always a very creative and innovative place. So you've confirmed that impression for us. We're now going across to Washington, DC, and Guilherme Roschke, if I pronounce that correctly, from the FTC's Office of International Affairs. Could we have your answers to the 2 or 3 questions, please?
Thank you, Richard, and bon dia to our colleagues in Brazil following along. I did want to start by noting that my comments here are going to be my own and not necessarily the views of the Commission or any particular commissioner, but I am happy to be here to provide some perspectives on the FTC's approach. I do want to thank Boyana, CIPL, and the IDP team for inviting me. I'm always amazed by the events you put together and the depth and the experience of the discussants that you get together. I attended a CIPL and IDP event in Brasilia, BCE, so before the COVID era, focused on LGPD while it was still being amended. And so now we find ourselves at the point of enforcement, or as we, as I've noticed you translate from Portuguese, in the application of the law. And this is where the FTC has most of its experience. And so when we're talking about the activities and priorities of the FTC, it's important to break this down into two different kind of components. One is, what will be the major privacy issues that consumers will confront? What are we seeing as these major issues? And the second is, what are the tools that the FTC has to address these and other issues? So first, on major issues that we're seeing, one is going to be the topic of algorithmic discrimination. With more people online during the pandemic, companies have collected and used more personal data for more purposes. And so when we look at and are concerned with algorithmic discrimination, we know that there's a clear list of factors that contribute to discriminatory or unsavory outcomes. And these include faulty inputs, faulty conclusions, a failure to adequately test, and the potential for discrimination by proxy. And so we have to take care that existing discrimination is not replicated, exacerbated, or potentially hidden in this algorithmic logic. And so the starting point for delivering algorithmic justice is increased transparency and accountability to mitigate these discriminatory effects. Transparency means that developers and deployers of AI and algorithms should make sure that these AI decisions are explainable and defensible. With proper transparency, advocates, academics, and third parties can then test for discriminatory outcomes. But transparency, importantly, must not put an untenable burden on consumers. Transparency must be accompanied by, at a minimum, accountability and proper remedies. Another pressing issue that we're seeing here is the increasing development and deployment of facial recognition technologies. Like algorithmic decision-making, facial recognition can also exacerbate existing racial disparities. There's obvious privacy implications in facial recognition. Identifying somebody just from a photograph, it's easy to imagine the concerns there. But there's also disturbing evidence that some of these technologies are less accurate at identifying non-white individuals, which has led to, here in the United States, documented cases of wrongful arrests of Black men. So in our enforcement actions against Facebook and Algorithm, for example, we challenge their default use of facial recognition technology, and we're going to continue to look for violations in this area. And finally, protecting young people's privacy is going to remain a significant part of our agenda. As schools shifted to virtual learning models during the pandemic, children and teens spent much of their school and non-school hours online. Educational technology and these other services used by children and teens are not going away after the pandemic ends. And so here at the FTC, we're currently reviewing our children's online privacy protection rules. We've also sent orders requesting information from 9 major social media companies about their practices, including information that might reveal how they're targeting and categorizing children and families. So given these topics, how will the FTC use its various tools to address these? Well, I think one of our first tools that we have and that we're increasingly thinking about is deterrence. When we consider how we resolve investigations, we have to think about the deterrence of future violations. And this is deterrence both by our defendants and by other participants in the market. And in order to have effective deterrence, we need to fully understand the benefits that companies might be getting from violating the law. So not only the financial gains that they're getting, but the benefits in growth, in opportunity, and competitive advantage that they might be reaching from violating the law. And so once we're better understanding these benefits, then we can pursue a remedy that ensures that companies would find these violations unprofitable. Second is we should focus on accountability at a corporate and, whenever appropriate, individual level. Here we should understand how close the violations get to the core of a business and how executive accountability could potentially change that corporate culture. Further, we need to look at transparency measures, such as I already mentioned before with algorithmic discrimination, but the publishing assessments and even including potential whistleblower protections could help to reduce problematic practices going forward and amplify and remove the need for further enforcement by the FTC. Third, we need to focus on helping the current victims. This has become a bit more complicated recently for the FTC, given a recent Supreme Court decision, but we often seek monetary remedies in our consumer protection cases, such as repaying consumers the money they lost or disgorgement of ill-gotten gains. But finding a monetary remedy in privacy cases in which consumers may have paid little or no money for a product or service is a challenge. But in cases for which monetary relief is hard or impossible to determine, we're looking at creative approaches to address consumer harms, such as disgorgement of ill-gotten data, meaningful notice, or renewed opt-in for existing consumers. So one recent example here is, again, our recent action against Everalbum, where instead of disgorging monetary benefits, we required the disgorgement of a different benefit that the company gained, the algorithm that they developed based on allegedly improperly collected data. So in addition to this case-by-case enforcement, we can also apply our rulemaking authority, which is another tool that we have to pervasive privacy problems. Clear rules can provide a guide for honest businesses and a strong deterrence for would-be rule breaker. And Congress has given us several authorities to write rules to help protect consumers. And so we've created here at the FTC a new rulemaking group to streamline our processes, strengthen our existing rules, and to look at undertaking new rulemakings to prohibit unfair, deceptive practices. We have long innovated in how we use our existing authority to protect privacy, and this is another tool with which we're looking to be creative. I should also mention the incredible value that we get from our workshops, cooperation, and our consumer and business education efforts. Our workshops help the FTC to refine our approach by deeply understanding and to deepen our understanding of an issue. It's been the case before on several topics that when a new topic arises, we receive questions from consumers, from civil society, from lawmakers. How are we going to address this issue? Well, often the first step is to just run a workshop because then we build up staff knowledge and experience. Even if we don't issue specific recommendations, this really builds up our capacity to learn and address the issue. And you can even see a timeline here when you look at the history. For example, in the case of smart TVs, where we first announced the workshop, gathered information from the public in an open call for comments, held the workshop, and then not too long afterwards, you saw our first enforcement actions against smart TV, a smart TV topic. I wouldn't, I didn't double check this, but I'm sure if you looked at our press releases, you would see this very similar names in the staff there who were involved in all three of those, because again, this is how we build up our understanding and apply our knowledge and law. Second to last, one of our tools is cooperation. We cooperate on technical issues with technical exchanges bilaterally or in multilateral forums like the Global Privacy Assembly, currently chaired by the UK ICO, or the Global Privacy Enforcement Network. We also have a specific law that authorizes enforcement cooperation, which allows us to share confidential enforcement information with counterparts abroad. And we can also host foreign staff here at the FTC working as part of our teams with access to confidential information, developing important staff level relationships, as well as sharing our knowledge and know-how in terms of how we actually operate. And then our final point here is on our consumer and business education. And this one is a particular favorite of mine, because I mentioned the point of deterrence above. You know, when one way to amplify our message to businesses is to make sure that they're getting the message from our enforcement actions. You know, when we announce a press release for the public, that's often for a general public consumption. We put up our legal documents of our cases as an important transparency measure, but also information out to the public. And I'm sure the lawyers follow along with that. But we also, every action that we announce, we parallel announce it on our business blog post. And here it's written in a language particularly understandable to small businesses, with lessons for these businesses on what the key takeaways and lessons from this particular enforcement action that businesses can take to avoid future enforcement action. And so I think I want to close by saying that, you know, these tools are important in their own, but I think are most effective when we think of them together as not just as one topic. So when we're thinking of deterrence, we're not just thinking about, you know, as we discussed earlier, what level of fine. We're also thinking about getting the message out. We're also thinking about making sure that we can cooperate abroad in particular enforcement actions or in sharing our knowledge. And so, Richard, back to you, and happy to join the future of the discussion.
Okay, thank you very much for that fascinating stuff. I picked up particularly what you said about what I might call behavioral remedies. The policeman doesn't just perhaps fine people or take money away. It can, I think you gave the example of renewed opt-in, requiring organizations to start again to get opt-in from their consumers to a particular practice. And that's a very good example, it seems to me, of you know, really using your weapons to change behavior in the marketplace. And I think what you said also about making sure that the message gets to the right people is hugely important. You know, authorities can write pages and pages of guidance, but making sure it gets through to the right people, targeting your audience is really important. We have two more panelists to go, and I'm going to move now to the University of Oxford here in the United Kingdom, where Professor Chris Hodges is Professor of Civil Justice Systems. And there are two questions we'd like to broaden out for Chris to address. First, is there a global trend for regulatory bodies to be outcomes and risk-based in their approach? And secondly, what lessons do you think that data protection authorities around the world can learn from other regulated areas? Over to you, Chris.
Thank you very much, Richard. And my thanks for today's invitation. And it's a great pleasure to talk to everyone. The answer to the first question, I think, is fairly simple. Is there a global trend towards outcomes-based and risk-based approaches? Yes. It is in some sectors and some countries at an early stage of development, but there is a clear evidence of trend. I operate together with the UK government an international network of regulatory experts. And for the past 4 years, we've been having discussions literally right across the world with different governments and different regulators in different sectors about what they're doing. And people are moving towards using these concepts of outcome-based and risk-based, which are completely linked concepts, and changing how they try and affect behavior. And I'd just like to say a few words about that. I believe that we are, if you like, changing our models of how we affect behavior, how we regulate, how we enforce. The traditional model is a linear model about saying, we'll make the rules, we'll identify breaches, we will impose penalties through enforcement, and everything will be wonderful, everyone will obey the rules. Well, as we've already heard, there are all sorts of problems with that. People may not have the attention or the resource or the priorities or the motivation to do that. And the theory behind it is one of deterrence, which comes from legal philosophy and economic theory. The second model is based on a problem-solving approach, and it is based on behavioral psychology. If one asks the question, why do people do things? Why do people break rules, for example? Why do they comply with rules? Why do they behave properly, ethically, or not? Then the answer surely lies in behavioral science of humans rather than legal or economic theory. And I speak here as a lawyer, professor of law. I think we've been looking in the wrong place. Now, what I do see is 50 years worth of learning on cognitive social psychology, going into genetics these days, a great deal of sociology, empirical research on enforcement approaches, what works, what doesn't work. And some people are understanding that and applying it, and some people are not. We've just heard two examples, certainly from Ireland, which is very similar to the UK, and Singapore, where virtually everything you said, I agree with. Your approaches are going to work. They're successful. We see similar points of interventions we've just heard about trying to help people from the FTC, but I believe there's a language problem, and a lot of it revolves around the words of punishment and deterrence, because I believe they're actually inaccurate words to describe motivations of people for, quote, breaking the law, and the mechanism by which we can affect people so that they do the right thing. Now, we're talking here about quite different situations, so one then has to get granular. At one end of the spectrum, you've got SMEs who don't have any resource. They're trying to stay alive. They're trying to develop their business, and they have enormous difficulty in dealing with anything, any type of law, tax law, workplace safety, environmental law, data law. You know, there are loads of problems they've got. How do you deal with them? Well, there's plenty of research saying you go in and help them. You support them. If you fine them, they may go out of business, or they may have to sack people. That doesn't help getting them into compliance. It's talking to them, supporting them, providing engagement, and certainly FTC and others have been talking about that. It's making it easy for them. At the other end of the spectrum, we've got very complicated, complex, large organizations. And you've got a different sequence of problems, which arises from organizational complexity, that people may not be able to do everything at once. They do an enormous number of things, but actually prioritizing different things. And a speaker earlier on talked about the importance of having a data protection officer who has access to the very top of the organization, who can speak truth to power in organizational terms, saying, look, we've really got to do something about this, or you've got to look at our policies, we've got to look at our systems, modernize, etc. So that also is about engagement and prioritization and talking to people, etc. So applying behavioral science to these arrangements is what works, and it comes into looking at how regulators work. A couple of years ago, I bullied various regulators into writing a book on something that they were talking about called the regulatory delivery model, which is this book. And it sets out a model for any authority, and it comes from a lot of work done through OECD and UK, Commonwealth, and third world governments. And it's got various elements, and 2 of the 6 elements are outcome focused and risk-based. And just one little comment, we're trying to produce good outcomes. We're trying to produce protection. That's the whole point of regulation, it's protection. But as soon as you say that, a lot of questions arise about how much resource should we put in, what should we prioritize, etc. But it's basically about protection and getting that issue on the agenda. Regulators, enforcers have limited resource, so therefore you have to be risk-based. What are the most important things? by the way, one structural point, which I'm very keen on, which I think the GDPR got wrong, is a regulator should not be a dispute resolution centre. Outsource. Other sectors have done this. Certainly in the UK and various other countries, we have external ombudsmen who are extremely good, who handle multiple numbers of small problems. They're very good at that. They can do it online or on the phone very, very quickly. And they then aggregate the data and they tell you, the regulator, what you need to know, what the trends are, who's a crook, who could improve things, what a new issue is. So it's a data function. But if you try and do all of this to yourself, you're going to drown, basically. So that's a structural change. Now, if one moves on here, how do we get some of these issues in front of people? And it's an issue I've been talking about with competition authorities for years, because they just regard themselves as enforcers, and they're very strongly into the economic theory of large fines lead to deterrence that leads to compliance, which, as I say, I believe is completely wrong. But they say, rightly, how do we get people's attention? Well, part of the answer is you work through other people. You work through covenants, agreements, engagement, trade associations, sectoral associations, networks, that other people will say, this is what you need to do about your tax compliance or your environmental compliance or your data compliance. And we've heard some good examples of that in previous speakers, actually putting taking a holistic view from the point of view of the recipient and looking at their problems in how to get there. So I believe that there are various tools like regulatory enforcement codes and enforcement policies. It's very good to hear a number of those being talked about, new policies, within which you can set expectations about saying, we will differentiate you. If you are consciously going out to break the law, and you're a criminal, you're involved in scams, you're involved in harvesting data for criminal purposes, etc., we will come after you, and it will be hard enforcement as much as we possibly can. That's fine. Please don't call it deterrence, because it isn't. At the other end of the spectrum, it's a question of not using the same tools, but actually supporting people, engaging with people, setting expectations, setting the barriers, working with ethical business codes, principles of ethics about should we be doing the right thing? Are we doing the right thing? Let's ask about it. Who do we ask? Are much easier for people in large and small organizations to remember than a vast number of rules. And working with that, which a number of sectors are now doing, is extraordinarily helpful. So one of the reasons I'm very pleased to be here today is that I was talking about some of these issues with the government of Brazil in meetings in Brasilia and University of Sao Paulo 2 years ago. And these concepts, frankly, in a country post-corruption is the idea. How do we do it? Well, let's get into ethical values and cooperation. And I'm told that the responses have been very positive indeed. And it's early days, of course, but I believe that an approach on ethical regulation, ethical business is immensely powerful. So other systems that I'm involved with, for example, talking to Australia about food regulation or Canada about retirement homes or measurement systems, are adopting these sorts of principles. And they're looking very positive. So that's the answer to the second question very quickly about can we learn from other regulatory systems? Yes, there's plenty of good stuff out there.
Well, Chris, we asked you to give some lessons, and as we would expect, you've shared many, many lessons, the importance of behavioral psychology, ethical regulation, perhaps segmenting your marketplace so you know when to use carrots and when to use sticks. I think you get that message very clearly. And maybe something more controversial about outsourcing the complaint handling role altogether, because it's unusual to have complaint handling done by a regulatory body. Thank you, Chris. Our last speaker, I hope, is with us, is Eduardo Bertoni, who is the former director of the Data Protection Authority in Argentina. He's now at the Inter-American Institute of Human Rights for South America. two questions for you, Eduardo. What are the main priorities for the Argentinian Data Protection Authority? And secondly, how can it work with AMPD in Brazil and other authorities in Latin America to enhance privacy protection, particularly on an outcomes and a risk-based manner? Because I think in Argentina you had a lot of experience with that approach. So over to you, please.
Thank you very much, Richard, for your question, and thanks to Bojana, CIPL, IPD for the invitation to be here today. As it was said by Richard, I'm no longer the Data Protection Authority in Argentina. I've been there until December 2020, and then I moved back, I would say, to the academic world, because the Inter-American Institute of Human Rights is the academic branch of the Inter-American System of Human Rights. So I'm the representative and coordinator of the South American office. I am based in Montevideo right now. And from the Institute, I continue working on data protection, and I am very pleased to give my views about the priorities challenge, not only for Argentina, but for other countries in Latin America as well, on how we can work together with the Brazilian authority and something of what you asked, Richard. I would like to start my very short presentation, no worries, mentioning something that it was not, or as far as I heard, it was not mentioned before, even though I agree with many of the challenges and priorities and strategies that my colleagues in this panel explained. But it is impossible to fulfill these goals, to complete a strategy, to fulfill the expectation of the people, if we don't work for having independent data protection authorities. And this is a very important issue in Latin America. Let me explain you the Argentinian history on that and how I worked when I was there. And that was one of our priorities, to move the Data Protection Authority in Argentina to a more independent office. At the very beginning, when the Data Protection Directorate was created in Argentina in 2001, after we passed data protection law, that office was part of the Ministry of Justice and Human Rights. So it was completely dependent of the Minister of Justice, and the director can be, removed by the only decision of the Minister of Justice, and can be appointed by the only decision coming from the Minister of Justice. So if the minister changed, the director could change. That was the situation in Argentina until 2016. And I would like to recall here that when Argentina got the, I would say, adequacy decision in 2003, the Working Party of the Article 29, Richard, you maybe recall that very well, said specifically, well, it's okay with Argentina, but they should do something to strengthen the independency of the authority. And Argentina didn't do anything until 2016. I, frankly, was appointed director of the Data Protection Office when it was in the Ministry of Justice. That was in 2016. But from the very beginning, I tried to work with the government to move the office to in another direction. As an academic, I wrote about this important issue in the past, so it was not very, it was not very coherent for me to stay there without doing anything or nothing. So I try to move to explain the government that it was important to move the agency, to move the office in another direction. So in 2016, Argentina passed the Access to Public Information Law. That law created an independent authority, which is the Access to Public Information Agency. So we worked to include all the data protection, regulations, or the regulator of data protection within the agency, which is a model very similar to the ICO. It's a model very similar to INAI in Mexico. So we had two hats, one access to public information and the other was data protection. And the situation was completely different. The agency is an independent authority. The director of the agency cannot be removed by the president of the nation without having a consensus with the Congress. The budget is that the agency have its own budget. So the situation was completely different. And we started working there. Then I was nominated by the president to be the director of the agency. After public hearings and all the procedure that was in the law, I was designated. I was the new and the first director of the national agency, which was the data, and which is now the Data Protection Authority in Argentina. Why this story? Because we worked hard to have an independent authority in Argentina. And we work hard, and people believe in that. Actually, after I left the office, there are some civil society organizations, and including people, Congress people from the opposition, that is pushing the president to nominate someone else to be independent, to have knowledge of access to public information and data protection and so on. The government didn't put nobody in the office yet, so people are looking what is going on. But we worked hard, and independency was important. And what was the other move that it was important? And I'm moving to your question on how to work with Brazil. We work hard also to be part of the international forums that deals with data protection. So the agency was part of the executive committee of the Ibero-American Network of Data Protection Authorities. We were part of the executive committee of the Global Privacy Assembly. We worked in having Argentina a state party of the Convention 108 and the Convention 108 Plus. We succeed. Argentina now is one of the countries that is state party of the Convention 108. And why that was part of the strategy and why that is important, and my recommendation to be part of this international forums. Two things. One is because it will strengthen the authority, the data protection authority. It could strengthen the independency, the autonomy of the authority. And second, it will benefit the work of the DPA in terms of enforcement because of the collaboration that you can get from other authorities when you are part of these international forums. Particularly the Convention 108 that opened the door to receive and give cooperation when we were doing investigations. The other thing that we did during my tenure was to push for a new law, but this is part of another conversation. And particularly with Brazil, my thoughts and my reaction is that Brazil has a very interesting new law, and it should work, in my opinion, to strengthen the autonomy and independency of the Data Protection Authority to fulfill the expectations that the internationally and locally creates that new law. And that is hard. And to work with Brazil is essential. And I would put I would focus my last comment on the Mercosur. The Mercosur is I would say, the coalition of countries in South America to create a common market like the European Union. It is not working very well, but this is part of another conversation. But the truth is that the Mercosur and the European Union are in conversation to have a, two blocks agreements. And I am very sure, I am convinced that among all of that conversation, data protection will be one of the issues. So what we will need now at Mercosur is to have common standards, to have common regulations, and to have regulations that are in accordance, that are in agreement with international standards. So Brazil is a key, actor in this conversation if we continue working for strengthening Mercosur and to having more economic cooperation agreement with other blocs and with other countries. So working with Brazil to increase the possibility to have common standard at Mercosur will be very, very important. So those are my views, Richard, for now, and I'm very open to receive questions and comments. Thank you very much.
Arturo, thank you very much. We're getting very short of time, but you've already answered one of the questions that have come in, because one of the questions from Elaine Keller was she'd like to ask about the possibility of creating a global data protection treaty due to the huge growth of information exchange in different countries. And I think you've started answering that question by pointing towards a possible agreement between the European Union and Mercosur, a two-block agreement in which data protection may well feature. From where I sit, we cannot talk about Brexit and leaving European Union, but certainly I think you've indicated that that will be a step towards a more global approach. Would any other panelists like to address that question? Is there scope for a more global approach to data protection?
Richard, I might just come in here and I suppose just add, of course, that there is provision for that sort of structure that's made in Article 50 of the GDPR, which foresees that the Commission, the European Commission, can develop international cooperation strategies. And I know that work has been ongoing to explore what those sorts of cooperation interactions might look like over the last number of years. So I think certainly it's worth noting that the GDPR does foresee that level of cooperation above and beyond the EU-centric cooperation that is in Chapter 7 of the GDPR.
Well, it's a big, ambitious project, but we heard earlier about the steel inside the concrete. So let's move in that direction. I'm going to have to close this session now because the very important session on accountability is about to follow. This panel has been about effectiveness. I think there's been a remarkable level of agreement and consensus across all 6 of our panelists. I think everyone agrees about the importance of priorities, of adopting an outcomes and risk-based approach. There was no controversy on that. We heard about getting the right balance between enforcement and guidance, but also heard that any authority can write good guidance, but it's really important to get it into the hands of the right people. We heard about the importance of remedies which change behavior in the marketplace rather than just punish or attempt to deter. We've discussed the position of complaint handling. Whilst it may be good for the individual complaints to have their issues addressed, it may not do very much for systemic problems. And we had a very powerful message at the end about the importance of a data protection authority being independent and being seen to be independent, and recognizing that a great deal of data is now held by governments and that many citizens have no choice but to share their data with the government. Perhaps the importance of an independent regulator to look at how government is behaving as well as how the business community is behaving is a very important message. So I think with that, I will say a huge thank you to all 6 of our panelists from around the world. It's been a fascinating panel. Thank you all very much. And I hand back now to Bojana, who's going to moderate the next session on accountability.
And thank you, Richard, and thank you all the panelists. What an amazing, amazing discussion. I've been nodding here and writing to various people. I so agree with this. And I really do agree. I think what we have heard, these panelists were there for a reason, right? Because they are, those who are data protection authorities are actually trying to be progressive and trying to apply some of this thinking in their daily work. So it really is important to understand what makes good regulation, good regulatory behavior. As you know, CIPL has always been promoting smart regulation, smart regulator, but on the other side, we've also been promoting accountability of organization. And we really think these are the building blocks of the good regulatory policy and good implementation of the laws. We need smart regulators and we need accountable organizations. And so now we of course need that engagement between the two and incentivization of that accountability. So now we actually want to look more into what does it mean to be accountable from practitioners' point of view, from the organizational point of view. And I've got with me an amazing panel of practitioners, data privacy, chief privacy officers in a number of organizations. And I'm going to actually have a sort of like a conversation with them. But before I start, and I'll introduce everybody as we kick off, I just wanted to set a little bit the scene, just like Richard did, to explain what do we mean by privacy accountability and why are we entering this, what I call age of accountability. So Isabella, just very quickly, and you have heard about this already at the previous panel. There is an increasing expectation by regulators, as well as in the laws, that organizations must be accountable, have a privacy management program, best practices, and be able to demonstrate and verify that they are accountable, right? And that's in GDPR, but it's also in LGPD. You have heard Singapore Privacy Commission, they are absolutely incentivizing accountability and moving accountability to the level of board requirement. FTC in its Facebook consent decree has actually set the scene as to what they expect companies to do. And we will hear about that in the panel as well. What does it mean to be accountable from FTC perspective? And this isn't about Facebook, it's about every other company as well. And in the UK, the ICO has published their accountability toolkit. We have got one in Canada. We've got more of similar in Hong Kong, in Australia. So this is becoming a global trend. It is also linked to what I call companies' responsible business agenda. We have got more and more companies who are seeing privacy and security as an area of corporate digital responsibility. You heard a lot about trust, and that's really where this comes together. It's not about legal compliance, it's really about trust. And that's where the boards are getting more interested in privacy. And we want, at CIPL, we are really promoting privacy as a board level issue. We want everybody to see this not as a matter of legal compliance, but as a matter of really business strategy. Data may be new oil, it may be the best asset we have, it may be the new environmental protection, but for every company, it's the most critical thing they have, and that's really what they need to ensure, that it's used properly, responsibly, sustainably, and there is trust in that use, right? And of course, investors are very interested as well, because they want to invest in companies who are also trusted from privacy and security point of view as well. And of course, COVID has just accelerated all of this. You heard from Simon McDougall, the whole need to be accountable is even more important when we need to share more data, when it's really much more processing of our health data as well for the reasons of COVID. Next slide, please. Many of you know that CIPL has been working on accountability, and this is our accountability framework. These are the 7 elements of accountability that we suggest companies should organize their privacy management program around, right? There are other frameworks as well. We just think this is quite useful and have done a really interesting exercise with 17 CIPL members where we mapped their privacy programs to CIPL's accountability. And we have a paper. Please, you can go to our website. We've got some links to have a look at that. But what's important here is that organizations actually have to translate through this accountability model legal requirements into operational controls, policies, practices, tools, technologies, right? And they must be able to demonstrate that internally to their boards, to their management, and externally to the regulator, to the stakeholders, and so on. And it's a really dynamic framework, right? It's never done. That's really important. You know, you all the time continuously improve and do this. And of course, you know, those of you who are, for example, thinking about certifications, you can actually certify your privacy program. We heard about Singapore, Brazil will have some as well. There are cross-border privacy rules certifications. Binding corporate rules is also a accountability framework. So there are very many different ways in which you can demonstrate accountability. But all of these models are based on these essential elements of what you should be doing as an accountable organization. Next slide, Isabella, please. In LGPD, we have accountability as well, and we will talk more. Article 50 talks about data governance program, and then Article 6 kind of sets the rule of accountability, which same is in GDPR, and as I say, same is happening in many other laws around the world. Next slide. We actually have mapped kind of the CIPL accountability wheel elements against requirements of LGPD, and we've done the same with GDPR, and you can do that against any law because it's agnostic of the law, right? It works for every law, and this just shows you how the two map. You will get these slides, and this is all available through our project as well. Next slide, please. I have mentioned there are lots of papers on accountability, but the really one that I suggest many of you may find it useful is this last one from May 2020, where we mapped privacy program to CIPL wheel. And there you will see the stories of what accountable organizations are actually doing every day and what it means to set up leadership and oversight, data protection role, officer role, reporting, or to do risk assessments, or how do you do transparency, how do you do training, etc., etc. And some of those participants are actually speaking on our panel today, so you'll have a chance to ask questions as well. And final point, next slide, please. Is, you know, why is accountability so important? Well, first of all, and what is the next step, right? First of all, we talked about is being adopted by regulators, it's being practiced by companies. And what we now need to do is to create global consensus as to what accountability really means and what are these universal elements, because all the regulators, all the data protection authorities, the boards, the auditors, the investors will be asking the same question. And we can't have 100 different views of accountability. It has to be sort of one, right? Secondly, we want to make sure that regulators really incentivize and promote accountability with companies. We heard from Ireland Commissioner Office, you have heard from Singapore, that's what they're doing, right? Christopher Hodges talked about change of behavior, change of culture. You don't change culture through fines. You change culture by incentivizing people to do well and making them understand why is it good for business to do so, right? We want to see more alignment of these regulatory guidance on accountability, right? There's going to be another one in Brazil. So it's important that when Brazil comes up with its regulatory guidance on accountability, that's aligned with what we are seeing elsewhere. Of course, there will be links between accountability and certifications, especially cross-border privacy rules. That is a certification that enables companies to not just share data, but comply in countries where they operate, but there will be others as well. And finally, how is accountability going to be used as a bridge, for example, to deliver these free and responsible, trusted data flows as well? Cross-border privacy rules, BCRs, these are all accountability elements. There will be certifications as well under GDPR, under LGPD. So how do we make sure that those accountable organizations are able to share data globally? So these are some of the next steps from kind of policy and regulatory perspective. But now I would like us to go back to basics, and I would like to invite my panelists to please come on camera and unmute their microphones. And I would like to start with our three privacy leaders in private sector: Rob Sherman, who is Vice President and Deputy Chief Privacy Officer of Facebook; Caroline Luvo, Chief Privacy Officer at MasterCard; Renato Leite Monteiro, who is a Data Protection Council lead for LATAM for Twitter. All of them are recognized leaders in their field and are running privacy in very big multinational companies. you also CIPL members, you're also working with us on CIPL accountability wheel and building your programs. So my question to you three to kick us off, could you give us a couple of examples of the specific accountability measures that your organization has implemented in this last couple of years, or perhaps even more? So what does that look like? And maybe what are the benefits of accountability for you as well? There has been a question which I'd like you to answer as well. How do you, as a global company, consider different regulation, and how do you build this privacy program to actually work with different regulatory requirements across the globe? So that's been somebody asked that on the chat. So over to you, Rob. Can we start with you? Maybe you are first on my list, and then we'll have Caroline and then Renato.
Sure. Thank you, Bojana, and thanks to everyone at CIPL and CEDIS IDP for this event. This is a really important conversation to be having, and I think particularly with LGPD coming online, a particularly timely discussion to be having. I think actually one of the things that you said in your introduction, Bojana, I think ties to the question that you're asking, which is sort of this idea of, and I think this is sort of embodied in how I'm hearing people talk about LGPD, the idea of data driving innovation and economic growth, and also having regulation that creates accountability and data protection, and the idea that you can have both of those things at the same time. Obviously, it creates work, which is what we're going to talk about on this panel, and it's hard to do all of those things, but I think the idea that we shouldn't have to compromise one for the other is really critical, and I think that's something that I took away from LGPD and a lot of the discussions that we've been having. I've been at Facebook for a lot of time, and so much has changed about the way that we're approaching privacy and data at the company, and we've been building updated frameworks and accountability measures to meet obligations that are evolving globally, whether that's GDPR in Europe or CCPA and our FTC order, which you talked about earlier, and now LGPD in Brazil. And it's a large effort that's spanning hundreds of people full-time and tens of thousands across the company at this point. So there's a lot that I could talk about. I'd love to focus just on sort of two things in some quick remarks here. The first is sort of how the question that you're asking, like how are we building a privacy program to meet global needs, including LGPD, but obviously lots of other things as well. And then what does that look like in practice on a day-to-day basis? So maybe I can just spend a few minutes on those two. In terms of sort of the structure of the program overall, we're obviously a company, as many of the folks represented on this panel are, that serves people all around the world. And so a fundamental responsibility that we have is to build products and build a privacy accountability program that is truly global in nature and that meets global needs. And so something that's sort of inherent in CIPL's framework, accountability framework, is sort of this idea of tone at the top. And that's sort of something that really becomes very important as we've built privacy and as sort of particularly over the last year and a half, 2 years, as we've updated our privacy program, has had very significant involvement by our CEO, Mark Zuckerberg, our Chief Operating Officer, Sheryl Sandberg, our two Chief Privacy Officers, and the Data Protection Officers as well that we've appointed. They're all very personally involved in the way that we make data decisions across the company, but there's also multiple levels of oversight. So we talked earlier, and I think in the previous panel, about accountability at the board level and making sure, and so we now have an independent committee of the board that we report to regularly on how we're approaching data protection across the company. We've also built accountability at every level of the organization. But one thing that I think is particularly interesting to talk about is as you pointed out in your question, Bojana, meeting expectations globally. There are increasing obligations in different parts of the world, but also different needs for different people and how they use our services. And so one of the things that we've done is to build out a regulatory implementation approach that divides our implementation into different focus areas, or what we're calling thematic areas. So for example, the people who work on consents are different than the people who work on youth privacy. And so when we built out our LGPD compliance program last year, ahead of the law coming online, this was a big part of how we thought about it. We really wanted to understand the law and split it up into different obligations so that we have different teams that, as there are new things that we have to do in different parts of the world, they're being considered holistically. And so that includes for LGPD things like including in our privacy policies and our products how people can exercise their rights under LGPD, specific ways that people can contact us, and a cross-company effort looking at legal basis, which I know is something that the ANPD is looking at giving more guidance on going forward. But another part that I want to highlight highlight is a big part of this is not just making decisions on our own, but I think in the last discussion on regulatory approach, the ability to consult with the ANPD on LGPD, but also with the Irish Data Protection Commissioner's Office and with the FTC about what their expectations are. Fundamentally, my job and everybody's job who works on privacy at Facebook is to meet those expectations, and especially when you have a new law coming online where there are questions about how it will be implemented, the ability to have that, to get guidance and to have that collaborative discussion is really important to making sure we're meeting expectations. But we also are trying to do that also with academics and civil society and other experts. And really, this project is actually a really critical example of how to do this, because I think, none of us are going to make the best decisions on our own. And so that's sort of the fundamental approach that we're taking. The second thing I wanted to talk about, though, is like what this looks like in practice. And there are a couple of pieces. The first is a company-wide privacy risk assessment. This is something that we're asking all business units that touch on data to do every year. So it's a top-down understanding of privacy risks and how we'll build safeguards to meet those risks. And the goal is, as technology evolves, as our business practices evolve, and as regulation evolves, that we're doing sort of a constant effort to understand sort of at the company level what the approach is. But then we have another process, which is sort of the core privacy by design mechanism and sort of the heart of the program, which we call privacy review. This is where LGPD analyses and analyses against our other obligations and other places happens. But really, it's not just about looking at legal obligations, but we have a cross-functional, cross-disciplinary group of people who at the very beginning of the product development process are thinking about how do we approach our obligations in these areas? What are we trying to build? What's the value for people? And how do we make sure that data is protected as a part of that? And so that ties back to the point that I made earlier around consulting, certainly with our regulators, but also with Facebook Ireland, which governs data in Europe, with our DPOs under LGPD, and also with outside stakeholders, governments, experts, academics, civil society, as we're making our decisions. And that's a critical part of our program at this point. And so I think, the way we think about this is partially about, making good decisions in the moment, but also using it as an education opportunity with the product teams across the company and helping them to understand both, how we are approaching privacy, but also why it's important and why it's important to building trust and building people's confidence in using our products. And so that's another part that over time is going to help us make future decisions. The last thing I'll sort of highlight is sort of the technical investments that we're making in this area. We've built an internal tool, which we call Launch Manager, which has become the sort of engine for how we launch products across the company at Facebook, just because it's such a comprehensive effort at this point. And so this is a purpose-built tool that tracks what we're building, what privacy decisions we've made, helps us maintain consistency and auditability over time, and those sorts of things. But increasingly, we're also investing in technical tools to automatically detect privacy-related changes so that we don't have to rely on people to trigger a review process, but actually we can detect it and make sure that that review is happening. And also related to sort of that investment is investing in education, so that as we're making these things, making these decisions and investments internally, we're also being transparent externally, both for accountability, but also to help people who use our services understand what's going on. So some examples of this, we've been publishing more blog posts. We have a new Privacy Matters blog where we talk about how we're approaching data as we launch new features. We just published a website that provides sort of an update on how we're integrating our privacy obligations and accountability across the company. It's the first time we've sort of captured that in one place. And increasingly, we're localizing privacy education to different parts of the world so that people who use our services in different places understand how their data is being used. And I think that's an area where we're going to continue to focus because of the recognition that privacy isn't the same for everybody, and what people need when it comes to how we're protecting their data is going to be different, and how they want to understand it is also different. So that's a little bit of the day-to-day of how we're thinking about it. It's a combination of sort of external consultation, top-down risk assessment, bottoms-up risk assessment, and then technical investments. So, I mean, I think I'll close by just sort of saying, like, this is it's something that I think increasingly, and particularly over the past year or two, the company has recognized as one of the essential responsibilities that we have to our community. We've done a lot of work, but I mean, I think as you'll probably hear from the other companies too, this isn't a job that will be done. We're not going to, hit an endpoint where we will be finished. But it's increasingly important with data flowing globally and more diverse needs from different people in different parts of the world who use our services to make these investments, and to do so collaboratively and consultatively. So that's part of why, I'm excited to be here today virtually, and also to be a part of this conversation and hear what other folks have to say. So thanks for the time.
Thank you, Rob. I think you. I'm not muted. Okay. I think what you're of course huge organization, and of course people are going to say, well, this is so easy, right? They're huge, but actually it isn't. As somebody has said, I think Chris Hodges said, actually complex organization is so complex that everything is very complex. But actually what you're saying is things that every company should be doing and trying to scale up, that tone from the top, the kind of risk assessment. Why does data matter, and what is the risk that we create? And then bottom up risk assessments and reviews on every product, and then educating people. So these are all CIPL essential elements. And I like your point about consultation, right? Even you have got how many lawyers, how many big, lots of resources, but you need to consult with regulators because everything is really gray and it's all the time moving. So these are really important lessons, I think, for all of us. Caroline, the same question to you. Caroline, long-standing Chief Privacy Officer, spearheading very mature privacy program for many years that has got BCRs, is looking into CBPR potentially.
We have achieved CBPR certifications, Boyana.
I'm sorry,
you missed that one.
I missed that one. I apologize. Of course you have. Apologies. My brain is gone woolly with the COVID last year. Okay. So what are some of the two examples perhaps you can share with us, and also address the global aspect? How do you build the global program?
Yes, absolutely. Thanks, Boyana. Thanks very much. It's a pleasure to be here with you today. So let me just get started by making a link to what Rob just said. I think the tone of the top is important. And so at Mastercard, the commitment to privacy and data responsibility also starts at the highest level of the organization with our CEO and the chairman of our board. And actually, both privacy by design and data responsibility are part of our corporate objectives. So that means that it's in the objectives of every single employee at Mastercard. And that's really critical to instill that culture of privacy and accountability across the organization. Now, let me give you two examples of how we have implemented accountability into practice. And actually, there are many, many different examples. I'm going to focus on two. First, as you just said, we have implemented binding corporate rules in Europe for all our activities. And we've also achieved CBPR certifications. And why is that? Well, they are much more than just data transfer mechanisms, right? They're tools to demonstrate accountability. Because what they're doing in practice is to require companies to demonstrate that they comply with the hardcore requirements of privacy laws. I would call it the what, but also that they demonstrate how to comply. So demonstrate that they have implemented tools, governance, mechanisms to ensure effective compliance. And so, for example, our binding corporate rules, which are posted on our corporate website, they demonstrate how we have resources in place to ensure effective compliance. So demonstrate the network of privacy and data protection officers that we have globally. They demonstrate how we provide trainings and awareness sessions to the organizations, how we conduct audits on our data practices, and how also we handle consumers' complaints, and we allow them to ask for redress and to get compensation if need be. So in other words, if you have BCRs in place, you have actually achieved to have a robust privacy and accountability program in place. It's exactly the same thing. And once you have that privacy program in place, then actually it allows you to comply with other laws globally, right? And even actually in other spaces. Sometimes actually it allows us, for example, to comply with AI, but we can talk about that later. So because for global organizations like ours, it's not possible, not sustainable to have multiple different programs in place. We have one single program that is based on the highest standards. And so at Mastercard, we decided to take the GDPR and our BCRs as our global baseline for designing all our products and services globally. And then obviously we adjust, we adjusted to the LGPD for Brazil, and we adjust to any other laws, right? There are new laws almost every day right now. But actually using one single strict standard allows us to, first of all, achieve compliance more quickly and to scale our innovation. So our business is actually really happy for us to use one standard, even if it's a really strict one. So I think I answered to that question about the globality. How do we handle the variety of different laws, right? So if I have time, I'm happy to give a second example that is even more concrete, I would say. Okay, great. And it's how we handle data breaches. And that's almost a taboo, but data breaches happen. It takes place on a regular basis. It's just sufficient for one employee to send the wrong file to the wrong customer. And so it's really, really important for companies to have a process in place to handle those data breaches. And actually the process has to reflect the accountability, all the accountability elements. So at Mastercard, we have a process and we've developed a playbook that is a step-by-step guide as to how to do, what to do when you have a breach. And so our playbook clearly allocates roles and responsibilities for each team involved. This is really important. You don't want actually to argue when you have a breach about who is doing what. And you don't want to forget about an important stakeholder because there are actually multiple stakeholders that need to be engaged. Your legal team, of course, but also your communications team, your account managers, your investor relations team, your board, your senior management, et cetera, et cetera. So very important. And we have also included checklists for each team because believe it or not, some people tend to go a little bit into a panic mode when there's a crisis. So having a reminder about step by step what they have to do is super useful. And then you want to make sure that you have the resources in place. So at Mastercard, we are obviously very lucky. We have a crisis management team dedicated to managing crisis. But if you don't have that, it's fine. Just it's important to identify some, maybe outside counsels or some experts that can help in times of crisis. And then obviously practice matters. So that's actually to the topic of trainings. And so we do organize tabletop exercises a couple of times a year to put our playbook into practice and to see where we still have gaps. This is an iterative process, as you said, Bojana, and we are improving as we go along, as we test it. And our senior management and our board members actually do participate in those tabletop exercises. So it's a top priority for the company. And the way that really takes place, it usually takes place over a couple of days. We receive a text message or an email from the crisis management team that there are indications of a data breach and that we are required to attend a meeting in the next half an hour. And you'd better drop everything that you're doing to attend that meeting. So that's how we do those exercises, which are truly useful and valuable to understand what's working well and what needs to be improved. And obviously, all of these, whether it's PCRs, the data breach playbook, it's obviously to ensure compliance, but beyond that, it's really to build trust. Trust with internal stakeholders and trust with external stakeholders. It's all about trust, as you said, Bojana.
Caroline, this is great. And there's several things there that I think we should actually consider. You talked about having procedures also to deal with consumer complaints and to think about what the last panel has said. Regulators are being swamped by complaints, but in fact, accountable organizations should be the first point of call for individuals who have got a problem or want to ask something or perhaps want to complain and understand why this has happened, why am I receiving this? And I think this is really important. Of course, BCR and CBPR, this is something that Brazil law enables. So these are some really important lessons as well as to how, as you say, BCR is also not just a data transfer mechanism, it's actually, it codifies your privacy management program, which Absolutely. I think is important. Absolutely. And it's interesting that these global companies really need the single program. It helps you then comply with the LGPD and then another law, India tomorrow.
And I think you improve it also, as soon as there's a new law, you can adjust the program. And right now, as you know, we have adjusted actually a program for AI. I think actually it builds and it becomes actually better and better, but you have to start somewhere.
Exactly. And finally, I think it's important to actually, thank you for mentioning security breaches, because security breaches happen even to the best organizations and accountable organizations as well. And everybody will have that. So being ready to deal with this and being accountable when this happens and dealing with regulators, that's a part of accountability as well. So we know that this is one of the priorities of IMP Day. So I think, again, Brazilian companies who are listening, there's a lot there to pick up as to how you organize your breach response and be ready for when something does happen. Okay, Renato, what about Twitter? Twitter has also participated in our accountability mapping project, and we heard some really interesting examples. So share with us perhaps some of these.
Claro, Bojana. Acho que tem alguns slides que eu enviei. Ótimo. Obrigado. Então, primeiro queria agradecer a CIPL, Bojana, Laura, Danilo, a Giovana pelo convite. É sempre muito bom a gente poder contribuir um pouco. E a ideia aqui, Bojana, como você disse, nós participamos do Accountability Mapping Reports, e trazer alguns exemplos bem práticos, bem próximos, que podem ser implementados por qualquer organização que nós temos colocado no Twitter. Então, próximo slide, por favor. Então, pode passar. Primeiro, eu separei os exemplos que é para trazer aqui em duas grandes áreas. Primeiro, como a Carolina colocou, o Twitter em 2020 estabeleceu privacidade e proteção de dados como objetivo corporativo. Na verdade, foi dos 4 objetivos que nós tivemos, ele era o mais importante, ele era o primeiro, e isso teve como consequência uma série de medidas que se espalharam por toda a organização. Próximo slide. E pegando na sua segunda pergunta, Boiana, e já também trazendo alguns exemplos, que agora, com a implementação da LGPD, o que a gente pode chamar de um Brazil Third Global Legal Approach, e como isso tem refletido em algumas das nossas estratégias global de privacidade. Então, próximo slide, por favor. Levando em consideração aqui privacidade como um elemento corporativo da organização. Então, pequenos alguns exemplos, a gente pode colocar de como todas as áreas, todos os times da empresa agora ficaram também responsáveis por atingir esse objetivo. Mas para poder facilitar isso, nós implementamos algumas medidas super práticas, como, por exemplo, nós colocamos a privacidade, elementos de privacidade e segurança da informação na Career Ladder, ou seja, na progressão de carreira de todo e qualquer funcionário da organização. Não é simplesmente aqueles funcionários, aqueles colaboradores que fazem parte do time de privacidade, do time de jurídico, segurança da informação. Então, por exemplo, isso serve para que nós possamos medir, inclusive, a eficiência dos trabalhos e o atingimento de objetivos particulares dos diferentes times, quando eles têm que estabelecer as suas próprias metas anuais. Isso nos levou também, por exemplo, a novas contratações e contratações focadas em segurança, privacidade e ética. E 2 exemplos muito simples, Boiana, que nós colocamos hoje, todo e qualquer colaborador do Twitter, independente de onde ele estiver no mundo, independente da área, independente da função, ele pode tirar uma certificação em privacidade e proteção de dados, como as certificações da IAPP. Né? Isso em conjunto com a criação do que a gente chama do DOVES Program, que seria o que a gente chama da Universidade Twitter de Privacidade, que ela também está disponível para toda a organização, e ela está sendo agora não só sobre o programa global da empresa, mas também regionalizada para aspectos como o LGPD, aspectos como o Japão e outros locais. A gente também, como sendo privacidade um objetivo corporativo, isso determinou que a cada trimestre o nosso time de privacidade, que é liderado pelos nossos Global Data Protection Officer, Dave McKieran, apresenta uma apresentação direto para o board sobre os riscos relacionados à privacidade e segurança da informação. O nosso Privacy Review Process, que foi mencionado aqui pelo Rob, nós não somente implementamos isso como obrigatório para todo e qualquer processo de desenvolvimento de novas funções, novos produtos e outro deal, qualquer negociação que envolva dados, como nós fomos diretamente ao regulador. Isso foi até curioso, nós fomos até o ICO, literalmente entramos, fizemos o login no nosso sistema de Privacy Review e explicamos para o regulador como é que isso funcionava e como é que isso era treinado para os nossos diferentes times. Uma outra questão muito interessante é que, como vocês sabem, a GDPR, ela determina que alguns aspectos de transparência, como colocar as bases legais publicamente, mas nós além de colocarmos as bases legais no nosso site sobre GDPR, nós colocamos um resumo dos nossos testes de legítimo interesse. Então, todo o exercício de balanceamento que nós realizamos para poder se valer dessa base legal para algumas finalidades está disponível para qualquer pessoa, para qualquer regulador que quiser conhecer um pouco mais sobre isso. E falando um pouco sobre o que nós fizemos no Brasil, próximo slide. Antes de nós começarmos o programa de adequação com a LGPD, o Twitter tinha 2 approaches. Era o approach com relação a GDPR, EU approach e o resto do mundo. Nunca tivemos uma preocupação, sempre alinhado com os standards globais de privacidade. Ano passado, que nós estávamos finalizando o programa de adequação, nós nos fizemos a pergunta, será que seria possível ter um approach regulatório diferente, um risk assessment diferente com relação à LGPD? Isso foi possível porque, primeiro, nós reconhecemos que, apesar da LGPD ter sido muito influenciada pela GDPR, ela é diferente. E eu gosto de falar muito, ela é muito diferente. Nós temos sim que aprender com os ensinamentos de 40 anos de história, com os reguladores que ele tem feito nessa troca de informações de experiência, mas ela realmente é muito diferente. E por isso nós fizemos um exercício de risk versus benefits. Quais são os riscos que nós estamos disponíveis, o impacto que isso pode ter nos direitos e liberdades fundamentais e os benefícios que isso pode trazer. Isso funcionou tão bem, inclusive a gente já tem conversado com o regulador, com a própria NPD, para mostrar exatamente como nós temos feito isso, que agora, como consequência, nós temos estudado ativamente a possibilidade de ter approaches regionais para outros mercados, como Índia, como Japão, como US, como South Korea e até mesmo para outros países da América Latina. Apenas lembrando que apesar de ser um approach regionalizado de risk versus benefits, isso está sempre alinhado com o programa global de privacidade do Twitter para tentar garantir aos nossos usuários, aos nossos colaboradores, o mesmo nível de proteção, os mesmos direitos, independente de onde ele estiver. Então, a partir disso, nós temos implementado uma série de outras medidas muito práticas, pragmáticas de accountability, que eu até convido para quem quiser saber um pouco mais a realmente ver o paper de Accountability Map Reports do CIPL, e que a gente colaborou ativamente, e fica aqui disponível, agradeço novamente, disponível para a gente continuar o debate.
Renato, this is excellent to hear. I'm particularly always loved, and I heard this before, how privacy has been defined as one of the top corporate priorities, and then it has been measured and become part of career and promotion and objectives of all executives. And that's actually how you implement accountability. That's how you change culture, right? Because everybody has to do it, and they understand why this matters as well, and really is important. I liked your point around transparency as well, that is, it's not just to individuals, it's not just giving legal notice, but it's actually explaining more, right, and understanding. And of course, the LGPD providing the third way, that really is important. As I've said in the beginning, you know, we are in the post-GDPR era. We have to actually innovate. We have to move on. So what does that look like in this new world of data? And I think you're absolutely right. Benefits and risks is the new way to actually measure a proportionality of our responses and compliance. And I think particularly in the area of AI, this is going to be very, very interesting. So thank you with that. Please, everybody, I see questions coming. I'm going to get through the whole panel and then we will open this for questions. Now, I would like to hear from a Brazilian colleague, Renato Bruce, who is data protection manager at the Bradesco, a big Brazilian bank. And in particular, Roberto, would be interesting to see, how does accountability translate? How does accountability actually, how does LGPD talk about accountability? And then how does that translate into operational practices for you in the bank?
Obrigado, Boiana. Inicialmente, parabenizo o CEDIS, o DP e o CIPL pela organização do evento, extremamente oportuno. E sinto honrado de estar no painel com pessoas tão ilustres e reconhecidas, tanto na comunidade de privacidade, né? Enfim, no cenário geral. Realmente uma honra. Bom, o aspecto da accountability, ele é base, nós entendemos como básico para tudo que a gente veio desenvolvendo, né, a partir do momento da discussão da LGPD, né? Apesar dele estar exposto no artigo 6º, no artigo 50, ele permeia todos os outros temas, né? Esse é de verdade o nosso entendimento. E o artigo 50, ele faculta aos agentes de tratamento, seja de forma individual ou através de associações, a definição de regras de boas práticas de governança. O presidente Valdemar mencionou isso no seu speech logo no início. O seu parágrafo 1º, ele condiciona essa liberdade à consideração dos riscos, ou seja, essa abordagem, né, levando em conta os riscos, mas também os benefícios envolvidos, como o Renato bem colocou. Já no seu parágrafo 2º, isso é interessante destacar, ele reconhece que os agentes possam ter e têm capacidades distintas, né, para enfrentar esse desafio, para implementar, para adotar essas regras. Isso, contudo, sem abrir mão da consideração dos riscos envolvidos. O setor bancário, né, onde o Bradesco está fortemente presente, ele é bastante regulado no Brasil, em especial quanto à proteção de dados. Até por isso, e agora falando da nossa jornada em específico, iniciamos, né, o nosso processo todo ainda em 2018. A lei ainda não tinha sido votada, ainda estava em fase de discussão. Dado o caráter inovador e em princípio lógico da lei, optamos por priorizar a demonstração do nosso compromisso, nossa boa-fé e a conformidade com a lei, em especial, novamente, com relação ao princípio da responsabilização e prestação de contas, né, accountability. Assim, eu vou falar aqui de algumas das coisas que nós fizemos. De verdade, foram muitas ações que aconteceram nesse período aí de 2 anos, né? A primeira delas foi a decisão por atuar de forma bastante dedicada junto à Federação Brasileira de Bancos, a FEBRABAN, que propiciou um fórum adequado para inúmeras discussões sobre quais caminhos seriam os mais recomendados, né, em razão dos artigos todos, dos desafios impostos pelos artigos da LGPD. Né? Então, lá nós contribuímos na criação do Guia de Boas Práticas para adequação à LGPD, isso ainda em 2019. Lá também foi produzido, nessa época, o primeiro vídeo falando sobre LGPD. Ele está disponível no canal da FEBRABAN, no YouTube, está disponível a todos, convido-os a visitá-los. Num segundo momento, também estabelecemos a importância do suporte do board, da alta direção da organização nessa jornada de adequação. Então, por exemplo, em reunião de diretoria, nomeamos o nosso DPO, definimos o Departamento de Segurança Corporativa como gestor do tema no Bradesco como um todo. O DPO tem o seu nome e o seu contato publicados em nosso site. Privacidade é tema formalmente acompanhado pela governança corporativa. Ele é pautado e deliberado em fóruns executivos. Nós também disponibilizamos, em atenção ao exercício dos direitos, né, por parte dos titulares, em especial nossos clientes, né, temos uma quantidade grande deles, disponibilizamos canais, né, para que, de forma segura, autônoma e facilitada, eles possam, de fato, exercer seus direitos, como, por exemplo, ter acesso aos seus dados pessoais, obter informações sobre os tratamentos que são realizados com eles, fazer gestão dos seus opt-ins e opt-outs, acompanhar o status das suas petições, o histórico dessas petições. Nós também mapeamos os tratamentos de dados realizados em toda a organização Bradesco, sistematizamos o seu registro, forma de gestão, integramos nessa ferramenta construída os pareceres de diferentes stakeholders quanto a aspectos como, por exemplo, a avaliação da base legal adequada para suportar, para sustentar aquele tratamento, a identificação dos riscos inerentes, as ações recomendadas, as ações mitigatórias recomendadas, boas práticas, com base em toda a experiência já disponível, em especial em razão da jornada de adequação à GDPR, né? Para que o gestor possa, enfim, tomar suas atitudes. E, ao final disso, nós temos ali, para cada tratamento proposto, né, ou registrado, o registro formal da aprovação ou mesmo da rejeição daquele tratamento por parte do DPO do banco. Conforme a classificação de riscos, o relatório de impacto e proteção de dados é produzido. Se a base legal for o legítimo interesse, o teste de balanceamento é feito e suas consequências são aplicadas dentro desse processo, né, contínuo de avaliação e aprimoramento e ajuste dos tratamentos. Do ponto de vista de conscientização das equipes, nós distribuímos, em 2020, o primeiro e-learning corporativo, né, e várias ações de comunicação interna foram veiculadas desde então. A Fundação Bradesco, em sua escola virtual, no site da escola virtual, ela disponibiliza um curso gratuito sobre o conceito da LGPD, aberto a toda a sociedade. Vale conferir, tá bem interessante. Inovação e definição de novos produtos e serviços adota formalmente o conceito de Privacy by Design. O Privacy Office, o Departamento de Compliance Jurídico, estão fortemente engajados em todo esse processo, né? É um momento importante de transformação. E é necessário que a gente conscientize mais e mais pessoas que tenham capacidade de multiplicar mais e mais essa nova compreensão. Nova sob o ponto de vista, né, do impacto disso na sociedade brasileira. A segunda linha de defesa, né, as equipes que atuam na segunda linha de defesa, também estão fortemente engajadas desde o início e elas já consideram, né, os aspectos relacionados à LGPD na execução de seus controles. As políticas de segurança da informação e de privacidade foram revisitadas. Elas adotam, né, desde então, uma linguagem, padrão visual amistoso, né? O foco está na transparência e na facilitação da compreensão daquelas informações por parte dos titulares de dados. A área de recursos humanos tem política de privacidade específica. Optamos por assim fazer. Para os nossos produtos e serviços, né, de um modo geral, os contratos, os termos de uso, receberam cláusulas, né, resultantes da nossa observância aos princípios da LGPD. O mesmo foi feito naqueles contratos firmados com nossa força de trabalho, com nossos parceiros comerciais e com prestadores de serviço. Isso é também um ponto, um aspecto, né, da mudança da legislação que traz um esforço enorme para todos os controladores de dados, porque não há uma compreensão exata de quais seriam as melhores cláusulas, quais seriam exatamente a forma de limitar responsabilidades, né, em especial em aspectos de impacto. Então, estamos todos desenvolvendo isso, e isso consome muita energia dos controladores em geral. Nossa percepção, né? A gestão de incidentes, também um processo já maduro dentro do banco, foi revisitada e ela contempla já o tema de privacidade, né? Em especial os aspectos relacionados aos novos desafios de comunicação, né, impostos pela LGPD. Bom, por fim, a gente sabe que isso tudo é um ponto de partida. É clara, né, a gente tem essa percepção clara, né, do tamanho da oportunidade que existe para a conscientização dos brasileiros quanto à importância e o valor de seus dados pessoais. Mas também com relação à extensão e os limites dos seus próprios direitos, assim como das obrigações, a expectativa com relação às obrigações dos agentes controladores. Nós vamos, de verdade, participar desse amadurecimento com muita vontade, refletindo ele em todas as nossas práticas, sempre pensando, né, naquilo que está no nosso DNA, né, que é o foco aqui no nosso cliente, na contribuição que a gente dá para a sociedade de um modo geral. Bom, eu acho que é isso, Boiana.
Thank you, Roberto. And you have said, you know, this is a journey. There is no precise way. By the way, they're doing really, translators are doing great job. It's not easy at all. So you said there's no precise way of going around accountability. But actually, Roberto, everything you have mentioned, all these examples are exactly the same things we have seen when we mapped privacy program of all CIPL members against CIPL wheel. That's exactly what everybody's doing. The exercise of RISE, the risk assessments, the training, education, contracts. It really is, I mean, it's amazing how companies are doing this irrespective of what law requires them to do that. And I particularly liked your point about, you know, second, first, maybe even third line of defense, again, leveraging what you have done in other areas of compliance and law or corporate practice, and learning as well, applying that in the world of privacy and security. Okay, let's move on, because I do want to let some time for questions as well. Marlon Dominguez is again CIPL member who actually works for university. He is a chief privacy officer for Erasmus University in Netherlands, and they also participate in our mapping project. And I particularly want to hear from Marlon. How do you, I mean, we've heard from big companies, big banks, you know, big social media tech companies, but how do you now scale accountability for university, right? What does that look, Marlon? Can you teach us maybe a couple of things that are the most important for all of us to hear? Thank you.
Yes, thank you so much. And thanks for the invitation to participate in this important CIPL and CEDIS IDP seminar. Well, the CIPL accountability wheel is our accountability framework, and it helps us in 3 ways. It makes sure we address all the relevant aspects, and even the order of the accountability elements is meaningful. So without leadership, the tone at the top, all following responsibilities are harder to address and let alone achieve successfully. So it is an easy to understand and explainable overall strategy. Second, it provides a context for our privacy maturity program. We now assess, for instance, in the privacy audit that is currently running at a university by an external organization, how well we are doing on each of the accountability elements in terms of maturity. So we also use it as a framework for a qualitative privacy audit. So yes, we have privacy policies, but is it fit for purpose, up to date, specific enough for the different organization units? And yes, we do a monitoring and response, but do we depend only on standard incidents and in general monitoring of networks, or do we need to do more? How can we quantify the data breaches by means of the oops emails, as I call them? And finally, it provides a structure for our privacy governance program. We realize that we need to be compliant on 3 levels within our organization, in the international collaborations our university participates in, and in the sector, the higher education sector as a whole. So the same accountability elements are valid in these 3 domains. Reporting on the board to the board and the senior management is more meaningful when actions, risks, and so on are structured in this way, in this wheel presentation. So basically, one can provide a clear, actionable oversight in a one-pager. In this way, applying the accountability rule makes it practical and operational for anyone with a responsibility within our organization to do justice to their own part in responsible data practices, ranging from data governance, data ethics, privacy engineering, even learning from data subject panels with regards to their privacy rights and their understanding of these rights, supplier, risk management, procurement, and implementing sandbox approaches for machine learning and AI. Finally, the Dutch DPA has adopted the CIPL accountability framework for their upcoming report of their snapshot of the privacy governance in the different sectors in the Netherlands. So in this way, it plays a very important role in not only in our own university, but in the sector as well.
Thank you, Marlon, as well. And I think it's just so interesting to hear that, in fact, this wheel or accountability approach has got also application within the university. And I like your point about it's not just helpful to actually build the program, but actually to also assess the maturity against the program. You use this to actually check where you are in the maturity space and to make it simple and easy to report as well as the other areas that are relevant for you. It's true that actually Dutch Data Protection Authority has actually particularly asked us to present on this, and they're using this to widely check with other companies and public sector and education sector on their status of accountability. So we hope we're going to see something from that as well. And that's exactly the point I meant, which is building consensus on the elements of accountability. Thank you, Marlon. Let's move to Tammy Dacken, who is the Chief Data Privacy Officer at World Bank. And Tammy, I've had a great pleasure and honor to participate in an amazing event you have put together at the World Bank for the Data Privacy Day. And I just want to say to people, you, of course, at the World Bank, you're not subject to GDPR. You're not subject to LGPD, right? You're an international organization, but one that has also built a really comprehensive privacy program that is all about trust and sustainability. And I just wanted you to share some of these lessons learned and some of your insights with all of us to kind of explain the value of doing accountability for somebody like World Bank.
Oh, thank you, Bojana, and it was such an honor to have you with us on Data Privacy Day this year. And you're right, as the World Bank enjoys privileges and immunities from following regulation, we are in a unique situation. I often use the analogy that you hear that somebody might be fixing the airplane while you're flying it. Well, in our case, we are actually creating the blueprint, building the plane, fixing it, all while flying it. So I will speak to that in a little bit more detail. But first of all, for those who aren't familiar with the World Bank, we are an international financial institution that provides loans and grants to governments of low and middle income countries. And the purpose of these are to pursue development projects. We have 189 member countries. We have staff from more than 170 countries and offices in over 130 locations. The bank was established right after World War II when a group of countries came together to pool resources in order to fund and finance the rebuilding of areas that were destroyed by the war. Our mission has evolved over the last 75 years, and we now are working toward our two twin goals of facilitating sustainable solutions to poverty and building shared prosperity in developing countries. So again, as an international organization, we are exempt from following any specific country's regulation, including data protection. But that said, the bank recognizes the risks of ignoring evolving attitudes toward the use of personal data and the increased adoption of data protection regulation. So for the bank, these risks include legal, business, and reputational risks if we are viewed as not being interested in or accountable to using personal data in a responsible fashion. So to address these risks, the bank voluntarily adopted its first policy on personal data privacy. So since we are self-regulated, the privacy policy is really our foundational regulation. The policy was adopted in 2018 and became operational on February 1st. The policy has 7 high-level principles that are found throughout data protection regulation throughout the world. And the policy requires the bank to use personal data for legitimate purposes in a fair and transparent manner, limiting the types and amount of personal data used, and so on. The privacy policy was adopted by the board, which represents all 189 member countries, which demonstrates the importance of this topic from the top level of leadership. So we're implementing the privacy policy both top down and bottom up. Specifically to the topic of accountability, our privacy policy's 7th and final principle requires accountability both internally and externally. Internally, we are required to adopt mechanisms to oversee compliance with the policy, and external accountability provides individuals, data subjects, with the ability to request information from the bank and seek redress for violations of the privacy policy. So our own court mechanism and regulatory framework, if you will. So the policy is a start, but we are building out the internal accountability mechanisms along the lines of CIPL's report on mapping accountability. So the privacy policy is the baseline, and then we are building out additional directives, procedures, and guidance to clarify what the principles mean and how to implement them. These implementing documentation documents include and address data privacy governance. At the bank, we are using the standard 3 lines of defense model, where all staff are responsible for integrating data privacy into their everyday work. My office, the Data Privacy Office, provides guidance, monitors compliance, and investigates non-compliance. And then we have our internal audit function that provides independent assurance of compliance. This decentralization means that everyone is responsible for how personal data is used. To facilitate that, we have a network of over 200 privacy focal points throughout the bank and in each business unit, region, and practice group. And these privacy focal points act as our liaisons in implementing the privacy policy. This is, as I like to say, building privacy into the fabric of the bank's work, or for this group, privacy by design. We have procedures for staff to follow for privacy self-assessments, data protection risk assessments, maintaining records of processing activities, and reporting personal data incidents. We're applying all of this on a risk-based approach where we measure the interest of the bank in using personal data against the likelihood and severity of harm to data subjects if that data is misused. So this is just a sample of the implementing documentation. A second area that I'll highlight are the risk assessments that we've done. We've conducted risk assessments of every business unit, region, and practice group to identify bank activities that involve personal data, and we've compared those activities to the requirements of the policy and are working to close any gaps that have been identified. The third component, my colleagues on the panel here have been speaking about, are the training and awareness efforts. Our outreach includes a new 45-minute e-learning course on data privacy, which is mandatory for all staff to take by September 30th. We have monthly webinars on data privacy. We have monthly data privacy roundtables. We have twice weekly open office hours for casual questions and interaction. We have given hundreds of specialized presentations to teams, from senior leadership to staff working in remote field offices. And as Bojana mentioned, I'm very proud to say that we've delivered two what we consider best-in-class events for Data Privacy Day. This year, 2021, our event spanned 2 days, included 13 events, 35 prominent privacy professionals, including Bojana, and more than 2,000 participants from around the world. Our closing event was a moving performance by an award-winning spoken word artist, a poet, who tied together the concepts of data privacy and racism. Lastly, I'll speak to how our efforts are spurring on additional work in this area with other organizations. The privacy policy was adopted to mitigate risks, but again, we don't have to do this. We choose to do this because it's the right thing to do. And the World Bank is choosing to do this in a way that emphasizes accountability, meaning that this is what we say we're doing, and we're able to demonstrate that we're doing what we say we're doing. We take our leadership very, very seriously. In addition to being a development bank, the World Bank is a very important knowledge bank for the world. So the bread and butter of the knowledge side of the bank is our massive troves of household surveys, which are conducted across the bank on large and small scale. Recognizing this, the Data Privacy Office is working on specific guidance on how to incorporate data privacy into the life cycle of these very critical and very detailed surveys. And these surveys inform the bank and others on issues such as poverty, lack of water, lack of identification, and other issues that necessarily need to rely on the use of personal data. We believe that we're the first international organization to factor this important work into the concepts of data privacy, which is so important to all of us throughout the world. So we're seeing that our leadership in this space is encouraging others, other multilateral development banks, other NGOs, and others to follow suit. We are working with others to share practices and integrate into other areas of the world. So thanks again for the opportunity to share what we're doing.
Tammy, thank you so much, and really is inspirational to hear this. Accountability is not just domain of big or small companies, it's also on public sector, on non-governmental organizations, charities, it's on international organizations. And I think what you're doing is going to set example for others. As you say, you are a developmental bank with 189 countries. So they're going to take that, and hopefully it will be a nice way to distribute accountability across the world. And thank you for reminding us actually the importance of data for your work as well. It's very different from private sector, but it's incredibly important, right? Data is actually going to enable better equality and better development and better, more just world, I really think. And I think that's why we need accountability to enable us to use data for those purposes. You also talked about demonstrating accountability. That really is important. And that brings us to our last panelist, and then we'll go into Q&A quickly. Who is actually Marcos Ottoni. Marcos works for CIPL, which is an interesting case study of a first code of conduct that has been launched in Brazil for health data to enable health data sharing and better use of health data. So we really want to hear from Marcos, how does accountability feature and how is accountability actually the same as the internal code for all of these health organizations? So Marcos, over to you. I saw him, now I can see him again.
Bom dia a todos. Bom dia a todos. Agora, Sim. Bom dia a todos, Boiana, bom dia a todos os panelistas. É um prazer também muito grande poder falar um pouquinho sobre essa experiência aqui na CN Saúde, na linha do que a gente tem, e Boiana acabou de nos apresentar, né, a mudança de paradigma no que diz respeito à regulamentação, à regulação do setor. Mudamos daquela regulação ativa para a regulação onde as empresas e o setor privado apresenta a sua linha de atuação e submete às autoridades os seus códigos de boas práticas. Nós, na Confederação, verificando um gap muito importante no setor de saúde, a Confederação ela representa a integralidade de todos os hospitais privados e clínicas de medicina diagnóstica do país. Então, verificando que há uma assimetria muito grande dentro desse setor, onde nós temos grandes grupos hospitalares com estruturas muito bem organizadas de privacy, nós temos também hospitais em diversos rincões do país, onde a gente possui, por exemplo, prontuários ainda em papel armazenados em cofres de chumbo, por exemplo. Até ouvindo um pouco que o Simon falou mais cedo, é um pouco reconfortante verificar que também no Reino Unido a gente encontra hospitais que também se utilizam de compartilhamento através de fax e que tem também uma assimetria também nesse sentido. Mas nós, na Confederação, tivemos uma preocupação muito grande no que diz respeito a essa assimetria e como a gente agiria agora com a vigência da lei e com os efeitos da pandemia. Porque o setor de saúde ele está sendo muito impactado, seja na necessidade de se ajustar dentro das suas organizações, suas políticas internas, organizar suas estruturas, mas também fazer um uso racional dos dados. A gente precisa, até para o combate à pandemia, ter uma utilização eficiente dessa estrutura. Então, nesse aspecto, nós temos surgiu a intenção, então, aproveitando que o artigo 50 prevê a possibilidade de se definir boas práticas, seja individualmente, mas também por meio de associações, em apresentar um código de boas práticas, um código de conduta com padrões mínimos, até para que a gente possa nivelar todos os entes. Entendemos que essa nivelação ela serve tanto para proteger os direitos dos titulares, mas também para garantir uma simetria comercial e evitar distorções concorrenciais também, porque nós sabemos que uma perfeita adequação de dados, um perfeito uso dos dados, ele permite ganhos para a empresa, ele permite um avanço muito maior, ainda mais nesse nosso setor que depende disso. Então, se nós deixarmos um hospital pequeno, completamente exposto à ação tanto de titulares de dados, de órgãos governamentais, mas também impedindo eles de plena realização comercial, porque, eventualmente, operadoras de planos de saúde vão parar de contratar com essa entidade que não está bem adequada. Permitimos que grandes grupos consigam um pleno desenvolvimento enquanto outros fiquem para trás, a gente entende que essa distorção só tenderá a aumentar. E aí, nessa questão, quando começamos a formulação do Código de Boas Práticas, a gente, ao invés de querer esgotar num primeiro momento todos os temas inerentes ao nosso setor, optamos por focar naqueles que afetam mais diariamente, no dia a dia de todas as instituições, querendo criar um padrão mínimo de informação e de regras de conduta, para que, a partir dali, a gente possa desenvolver, juntamente com a ANPD, os demais patamares. Então, focamos inicialmente desde a questão da coleta dos dados, logo quando o paciente dá entrada no hospital, como se daria isso, qual o enquadramento da base legal para determinados tipos de dados. Focamos muito na questão da segurança da informação, ao estabelecer critérios mínimos que sejam razoáveis, sempre levando em consideração essa peculiaridade técnica e econômica, da fragilidade de alguns elementos. Então, trabalhamos para definir os padrões mínimos, para depois, claro, passando para níveis 2, terceiro nível de segurança da informação, um protocolo que foca na pesquisa clínica, e aí, mais do que nunca, nesse momento, é importantíssimo até que hospitais, nos mais diferenciados rincões do país, que estão tendo contatos também com pacientes, que possam ter acesso a informações importantíssimas de diversas doenças, diversos tratamentos, que eles possam criar um padrão de pesquisa também único, que possam criar um padrão que atenda aos interesses do titular dos dados e o desenvolvimento da ciência. Focou-se muito também no aspecto do compartilhamento. E aí até o que o Simon também chegou a mencionar mais cedo, né? O compartilhamento na Europa, a GDPR ela não chega a criar tantos limitantes. Porém, no Brasil, nós temos a nossa LGPD, até uma vedação expressa nesse setor, a vedação de se utilizar o compartilhamento para a criação de seleção de riscos. Então, por parte de operadoras de plano de saúde. No entanto, a gente tem também o permissivo de compartilhamento no que diz respeito aos procedimentos para a operacionalização da atenção à saúde. Então, como compatibilizar esses elementos? Como compatibilizar um intenso compartilhamento de dados com as autoridades reguladoras, a ANS, por exemplo, o próprio Ministério da Saúde, que é o poder público? É aí que a gente buscou, ao apresentar regras mínimas de accountability e de observância das normas que preceituam o LGPD, a gente entende que isso a gente vai conseguir nivelar todos os players desse setor. E, por fim, a gente temos até, para não nos alongar demais, a gente tem um conceito que o Código de Boas Práticas ele não é um documento que se resume na sua apresentação, na sua formulação. Ele é um elemento vivo, ele é um elemento que vai sendo aperfeiçoado com o tempo, ele vai sendo aprimorado de acordo até com a dinâmica da vida. Então, no caso da saúde, que particularmente eu acredito que seja hoje o setor que mais tem enfrentado o desenvolvimento e o fomento do uso dos dados para o seu desenvolvimento, entendemos que esse código só vai conseguir ser efetivo a partir do momento que for criado também, e é isso que a gente está fazendo agora nessa próxima etapa, é a criação de um fórum permanente de discussões desses pontos que foram apresentados no Código de Boas Práticas, mas também uma discussão que permita trazer tanto a ANPD quanto a Agência Nacional de Saúde e todos os players do setor para que a gente possa subsidiar uma discussão de mais alto nível. Entendemos as dificuldades que a ANPD está vivenciando nesse momento, então, assim, uma das ideias também foi a de possibilitar o oferecimento do nosso ponto de vista, e essa é um dos preceitos do Código. Entendemos que o Fórum Permanente vai aprimorar esse uso, vai permitir com que cada novidade, seja agora os novos aplicativos, seja o novo conceito de gestão de saúde, porque a nossa LGPD ela preserva como base legal a tutela da saúde. Mas e como que é o novo conceito de gestão da saúde, que é aquela que eu estou olhando para frente, não curando uma doença aqui propriamente dita? Qual a base legal que eu vou enquadrar isso? Seria o consentimento? Como é que são termos que, com o passar do tempo, vão sendo colocados à prova para o setor e que, para isso, a gente entende que o aprimoramento do código vai subsidiar essa análise mais profunda da autoridade e vai também auxiliar desde o grande estabelecimento ao pequeno, para que a gente possa nivelar o conhecimento e, no final das contas, e no final de tudo, proteger quem de fato precisa, que é o titular dos dados. Acho que, em linhas gerais, seria isso, Boiana. Eu agradeço demais a possibilidade de falar um pouquinho sobre isso e prazer em revê-la.
Thank you, Marcos, and congratulations again for achieving this code so fast, because we in Europe are 3 years into GDPR and have got just a handful of codes, not even approved. So it really is important to do this. And I think you have demonstrated how important it is to have this in the area of health. And we need to ensure accountable data sharing, right? And that's where accountability can help. So we can use data and share health data for the beneficial purposes. There are a couple of questions that we have received from the chat, and I would like people to answer. The first one is more on kind of the risk-based approach. So the question is, how does LGPD incorporate risk-based approach? All of you talked about your accountability being risk-based. And we know that GDPR has risk-based approach, but actually LGPD does as well. So maybe just talk a little bit, if several of you can maybe quickly address, how does Brazilian law, maybe Renato, Roberto, incorporate a risk-based approach, and then maybe others just to kind of explain again how they do these risk assessments. Several of you have mentioned doing risk assessments. So Renato, do you want to just touch upon Brazilian LGPD and risk? Yeah.
Claro, Boiana. Até pegando um pouco aqui dos detalhes da pergunta, eu acho que foi até mencionada rapidamente aqui uma teoria específica de desenvolvimento de produtos e serviços que é aliada à teoria de risco, né? Que seria a teoria do risco do desenvolvimento, que seria o risco de colocar um produto ou serviço no mercado sem saber as consequências que ele poderia ter. E o que nós temos na LGPD é justamente por meio dos instrumentos de accountability, como o Privacy by Design, e a implementação desses instrumentos de como demonstrar efetivamente o cumprimento das obrigações e o assessment de risco, que a gente pode endereçar essa teoria. Então, vários dos exemplos que nós trouxemos aqui hoje, como o de Privacy Review, a obrigatoriedade de Privacy Review no desenvolvimento de produtos e serviços é um exemplo de como, de melhores práticas, a gente pode incorporar no desenvolvimento interno das corporações esses assessment de risco. E, pegando um pouco até do que eu falei, a LGPD também nos traz instrumentos para fazer o assessment não só dos riscos, mas também do benefício. E o impacto que isso pode ter nos direitos e liberdades fundamentais dos titulares. Então, passa até muito similar a outras estruturas de desenvolvimento que nós temos de outros produtos que estão até muito alinhados com o Código de Defesa do Consumidor que nós temos desde 1990.
Thank you. Would anybody else want to comment on this?
Opa,
Roberto?
acho que agora estava tentando aqui, acho que agora vai. Eu concordo com isso tudo que o Renato acabou de colocar, e eu traria um complemento sob o ponto de vista da percepção dos titulares, né, dos titulares de dados, com respeito ao que seja de verdade accountability. Porque, como não há uma definição clara, né, por exemplo, ser transparente, né, nas decisões que o Marcos Ottoni na área de saúde eventualmente venha direcionar, pode ser diferente do que seja ser transparente na indústria bancária, né, no ramo de seguros, enfim, em outras áreas, na indústria de entretenimento, né? Então, a expectativa de que os titulares tenham do que venha a ser, por exemplo, transparência, o grau de informação que a gente fornece quando explica como são os tratamentos de dados, isso tende a gerar, na nossa compreensão, isso tende a gerar dúvidas. E essas dúvidas podem acabar se refletindo num grande volume de reclamações à autoridade de supervisão. Então, como nós mencionamos aqui na nossa fala anteriormente, a oportunidade e talvez a prioridade em se nivelar esse nível, essa expectativa em toda a sociedade, seja algo benéfico para todos os setores, em especial para a autoridade reguladora.
That's a really interesting comment. I like that one. Can I ask everybody else to maybe give some sort of closing remarks, or to think about a closing remarks? And I'm going to ask a question, which is, does accountability enable us to anticipate, things like new technologies, for example, things like AI, right? Use of AI, machine learning. Is it translatable? And I think Marlon, Rob, I'd like to hear from you too. I know you're both working on AI, but everybody else as well. Either answer these questions or give some concluding remarks, and then we're going to end up. Rob and Marlon, yeah?
Go ahead, Marlon.
So thanks. So one of the things that we did is invest in going from principles, so AI, human-centered AI, and so on, to the practical stuff. So what does it mean? What do all these in the different contexts? What do all these meanings mean? What is good, and so on? And then from these guidelines and these practical privacy requirements to privacy engineering steps. What does it mean for the engineers? And that is a very different and a very interesting discussion where you get all these new questions that are far more interesting. And all the bias topics are addressed usually, and so on. But this is a very different topic. And how do you check your privacy requirements and that you do not bake in your bias and so on. And so these are the approaches that we are trying to address with different groups, different expertise, legal people, but also the design people, the people that make the functionalities and so on. And this is very and the data scientists. This is very interesting. And then we come up with one last remark. We come up with solutions like we need synthetic data to play around more with data and have a safe environment to fail safely. And because we are actually very much learning, and we are learning very much, and so we need this sandbox approach from a technical point of view. So these are some things that we really, which are very not so much touched upon in most discussions, and it's very interesting. Thanks.
Okay. Thank you, Marlon. Rob?
And just building on what Marlon said, I mean, I think accountability is in many ways the sort of structure and the rubric that enables us to make good decisions with the technology that we have today. But I think as you're saying, Boyana, with the technology that we're building now and that we'll be building over the next many years. And so the way that we've thought about this is we have this concept of privacy expectations that sit over and above the sort of baseline legal requirements that we have. That's built into our privacy review process. It's built into the training that we require all of our employees to undertake, et cetera. And it's basic things like data minimization and sort of those like bedrock concepts of privacy regulation, but also things like fairness and making sure that as we're using data, we're doing it in a way that provides value to people and that thinks about the differences in how a particular decision will affect different groups of people. And so what that means is some of the questions are pretty straightforward, but actually, as we're building new technology, some of them are going to be harder. So for example, to go to the AI example, we all agree that we need to have fair machine learning models and we need to avoid bias. But how do you do that? So the sort of accountability process that we had around our use of machine learning models caused us to build technology to do fairness assessment so that we can actually detect when a model has disparate impact on people. And so that's one example. Another example is we all agree that transparency is important, but how do you make a machine learning model transparent? And so we're doing work on model cards and also collaborative work on, like we have design jams and other exercises with expert stakeholders outside the company to figure out how can we actually explain this. And that's led to improvements in why am I seeing this ad, or letting people see why we decided to show them a particular story in newsfeed. And those are all things that come out of our accountability program. I think that this is only going to get more complex and harder, and so these collaborations are important. I mean, you can see behind me on my desk here, I have my Oculus Quest, and as we're building AR and augmented reality and virtual reality technologies, again, some of the questions that we're asking are going to be consistent, but there are also going to be new questions as we're building augmented reality technology. How do we think about the rights of people who are bystanders? And so we're doing a bunch of research internally, but also funding external research to start thinking through these questions and building the insights from that. Obviously, like that future is a long way out. We're not talking about tomorrow, but building those insights into the way that we make decisions day to day is a core part of how we're thinking about accountability as we innovate.
Right. So accountability is really a roadmap for the future as well. It makes us more comfortable going to that future. And please, of course, Renato wants to word, Marcus and others. There has been a question: how do we make this a C-suite and board level issue? And what happens to companies who are slow to do that? I'd like you to also address that, please. So, Marcus, over to you first.
Pois acho que a responsabilidade ela vai ser fundamental, principalmente no setor saúde, porque aí, ao contrário do que o Marlon e o Rob mencionaram, a gente não tem muito como errar, porque a gente está lidando com saúde, então a gente tem que ter um cuidado adicional nesse aspecto, né? Então, a responsabilidade no nosso setor, ela ainda é muito maior. A questão da coleta dos dados para que uma inteligência artificial possa, de fato, ser precisa e eficiente, ela é muito maior. E aí a gente envolve uma preocupação que o setor privado tem, é a interação com o público, porque aqui no Brasil, particularmente, a gente tem uma interação com o sistema público e o privado, mas não temos o mesmo nível de cuidado, de controle e de coleta de dados. Ontem, inclusive, foi aprovada uma lei no Senado aqui para criar um prontuário eletrônico único, né? E como vai ser isso? Como vai ser essa gestão? Foi puxando, inclusive, a recente legislação americana que criou o prontuário eletrônico único, onde todo mundo pode acessar os médicos de cada paciente. Mas como que isso vai se dar aqui? Aí a responsabilidade, ela se mostra ainda mais importante, e os gestores, como a Boiana perguntou, os gestores privados, principalmente, já estão muito atentos a isso, sabem do impacto direto na vida e na qualidade de vida dos indivíduos, e por isso que a gente busca tanto essa adequação, essa conformidade, para que a gente possa aproveitar, de fato, esses novos ganhos.
Thank you, Marcus. I'm with you. Renato?
Agora, pegando rapidamente sobre a sua primeira pergunta de accountability, algo que a gente tem feito muito no Twitter, utilizando de meios de accountability para desenvolver o nosso sistema de AI, implementando metodologias de explainability by design. Então, até de explicação por concepção. Até numa recente audiência no Senado americano, Jack, nosso CEO, falou que ele desejava ser mais transparente, permitir que nós pudéssemos explicar efetivamente como nossos algoritmos funcionam, ao ponto que algo que nós estamos desenvolvendo internamente é o que a gente chama de Marketplace for Algorithms. Então, um mercado de algoritmos, em que as pessoas, os usuários, elas podem, ao entender o impacto que esses algoritmos podem ter nos seus timelines, nos seus conteúdos, inclusive nas suas vidas, escolher o melhor tipo de algoritmo que seria para ela. Então, a gente tem realmente nos valido de instrumentos de accountability para poder desenvolver melhor nossos instrumentos de AI, e inclusive até mesmo tem influenciado nas contratações que nós fizemos recentemente.
Excellent. I love hearing the really concrete examples of how companies are tackling this. Tammy, any comments on some of these questions from you, including the C-suite and board?
Oh, it's a perennial exercise, I think, to convince leaders that this is a topic that needs to be addressed. One quick thing that I'm using is there was a recent survey conducted on poor populations in India and Kenya, and showed that individuals living on the very, very fringes, on the edge with little to nothing, still would give up their time and money in order for the promise of privacy. This was just a remarkable study. It was conducted in 2 phases, one pre-pandemic, one mid-pandemic. In mid-pandemic, the results were even stronger. So I use that to show that this is, it's the right thing to do. It's what, our countries are doing, but this is what individuals want as well. And it's not just limited to one socioeconomic angle or group of people. So looking for angles like that, just to convince that it can be a competitive advantage for a company to have a privacy forward posture and get the interest of the C-suite. So, but great question, and certainly one I know that we all here grapple with.
Exactly. You have to find that Achilles heel, like what makes this C-suite tick. Rob, I think you'll have the last comment probably.
Okay, I just wanted to call out one aspect of the question, which is sort of the cross-disciplinary nature of doing privacy well and building an accountability process. In our process, we have obviously a team of lawyers who are responsible for compliance, a team of policy managers who are responsible for thinking of the things that are legal for us to do, what should we be doing, but also we have a product team focused on treating privacy as a first-class product, an engineering team working on how we handle data across the organization, but also designers and user experience researchers to understand how the experiences that we build actually are understandable by people and how people use them. And I think the thing that's been fascinating is as we've been having these discussions through our privacy review process, the different disciplines and the different perspectives come together to help us make better decisions. And I think, going to the other part of the question around escalation, having an explicit path to escalation to a group of senior decision makers and then to our CEO if necessary has been really important, and empowering each of those disciplines to escalate if they disagree with the approach has been a really important part in just empowering individual decision makers to get to the right answer. And again, we're not always going to get it right, but I think empowering people, getting the right ideas in the room and empowering people to do that has been useful. I mean, I think, we're talking about, how do we get the, the leadership to focus on this? I think, for better or worse, like, I think everybody at Facebook realizes, our data fundamental, or our business fundamentally requires us to handle people's data. If we don't do that in a trustworthy way, then we're not going to be successful. And so I think, that's the reason why we have such heavy involvement by our board and by our senior leadership. I mean, it's just a business critical thing, and it's something we have to invest in and get right. But doing that cross-disciplinary way is a key part of sort of how I see our success over the next couple of years.
Absolutely. And that brings us to what Simon McDougall in his keynote said, one of the things that data protection authorities have to do is be cross-disciplinary, have a skill set. And I think I've said the same is internally. We need lawyers, engineers, user design, marketeers, normal people to kind of give us the view, and employees, representatives of employees to give us the view on what we think is right and which way to go. Well, listen, thank you everybody so much on this particular panel as well. It's been such a rich and amazing discussion. If we were live, we would have gone for a whole day and we would have discussed deeper, but everybody needs a break. I need my tea. I'm in Britain, it's tea time here. But it's been phenomenal. I have learned a lot, and really huge thanks to my friends and colleagues at CEDIS, IDP, Isabella, Giovanna, who have made this possible, and all the panelists and speakers. We are just going to continue this, as you know, tomorrow again with a different group of keynotes and speakers, and on Friday. So please join us again, and thanks everybody. Have a wonderful day. All the best. Bye-bye.